Royal Commission is now in session. Please be seated.
Yes, your appearance, please, Mr. Freedman.
If it pleases the Commission, my name is Freeburn, initial D. I appear as counsel assisting, and I'm assisted by Miss Berry today.
Thank you. Ms Hogan-Doran?
Yes, I appear today with Mr VR for the Commonwealth.
Thank you. Yes, Mr. Freeburn?
Commissioner, I call Miss Sandra Bevan.
All right, are there any, just before we start that, are there any exhibits for the day you want to tender, or will we do that later?
Yes, Commissioner, I was proposing to do that in a moment.
All right, fine. Ms Bevan, now, would you prefer to take an oath or an affirmation?
An affirmation, please.
Okay, well, what I'll get you to do is just stand up for that.
As I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Yes, Mr. Freeburn.
Thank you, Commissioner. Miss Bevan, can you tell the Commission your full name, please?
My name's Sandra Jean Bevan.
And you're currently living in Brisbane in the state
Yes,
of
I
Queensland?
am.
Miss Bevan, did you prepare a statement in preparation for giving evidence in this
Yes,
Royal
I did.
Commission dated the 13th of December of 2022?
Yes, I did.
And in preparation of that statement, did you have regard to a range of documents produced by Services Australia in respect of your Centrelink file in 2019?
Yes, I did.
Commissioner, I tender the statement of Miss Bevan and a number of related documents, including NTG 71 to Services Australia, being the notice, the response to that notice, and a number of attachments.
All right, so we're going from 2809 down to 2836, are we? Is that right?
I understand it to be 2839.
They're really on documents, but you're doing them all? That's fine. Exhibits 2809 and down to 2839 as numbered on the exhibit list will be admitted with the numbers they bear on the list. Okay.
Thank you, Commissioner. Ms Bevan, I'm going to start by asking you some questions in relation to your background.
Yes.
Can you explain to the Commission your family situation?
I'm the mother of 4 adult men, but at the time in question they were much younger. I'm a single parent, and I became a single parent after separating from my husband, who then later passed away.
Thank you. And it's the case, isn't it, Miss Bevan, that you've worked in the aged care, disability care sector for a period of time, is that right?
Yes, I've worked as a disability support worker and in aged care, well, in disability support really since the time I was 16 years old. And then I've gone on to get a variety of qualifications in that area and in aged care, including a bachelor degree in counselling.
Thank you. And Miss Bevan, can you describe in broad terms the nature of your work in the disability aged care sector?
Yes, I can. What I would say in a general sense is that I do a range of activities, sort of ranging from day-to-day care of people, doing things like showering and preparing meals, all the way through to assisting people into working toward changing behaviours so that they're able to really live their life to their best ability. So really I'm enhancing people's lives, and in turn by accident they're enhancing my life.
And Ms. Bevan, can you describe the kind of client who you typically deal with in that area?
At the moment, I'm working privately just for one family, primarily with people with autism. But in the past, I've worked for people with spinal cord injuries, people who are at the end stage of their life and would like to have care in their home rather than in a nursing home, to the point where they palliative care. So it's a very diverse job that I do. For example, in the time in question that we're talking about today, I was working for 3 different organisations, and it wouldn't be unusual for me to get up early in the morning, go and help somebody get out of bed and ready for work, go home, get my kids ready for school, and then go and run an art class, for example, at an organisation with either kids or adults, and then on the way home, go and help somebody prepare their meal, or even in the palliative care area, I would stay overnight with people and then get up in the morning and go home, and that kind of, that was my day. So it's quite a diverse kind of job, and that's actually why I love it so much. It's so much that I can do. And it's just such a wonderful thing to see people reaching their potential and doing things like my client at the moment composes music and is about to enter university, and I'm so proud of him and I for working towards these goals.
Thank you. And that leads me well on to my next question, which is, what's your sort of motivation for working in that area?
Well, I can tell you it's not money. I just love that job of seeing people reach their potential. It's just such a wonderful thing, and really seeing people go from a point where they're anxious and they're really not feeling very good about themselves to really doing amazing things, you know, with their lives. And that can be just as simple as having a non-verbal person or somebody who's struggling with language, running a Dungeons and Dragons campaign with his friends. You know, something like that is a big achievement for me and for my clients. It's such a lovely job, and I just enjoy going every day. You know, I wake up every morning and I'm just think, what kind of adventures are we going to get up to today? The family that I'm working with now, we went kayaking down the Gold Coast, and you know, we just had a really, even though it seems like a leisure activity, it's confidence building for people, and I just love that. I just love seeing people blossom, really. And even in my counselling jobs that I've done too, it's just fantastic seeing people reach their full potential.
Thank you.
And the money is really not that big a deal.
I expect it's not that big a deal in terms of amount as well as...
No, it's very poorly paid, unfortunately. It's a job where people are... It's not an unusual thing for people to say to me when I say I'm a support worker, for them to say, so you take people out for a cup of coffee. Or, you know, or you take people out to a movie, do you? It's such a much more complicated job than that, and I do use all of my training that I've had and in doing that job. You know, and really it's in Melbourne when I was there working in houses with people coming out of institutions, the hourly rate was $14 an hour, just to give you an example, and $21 to $22 an hour if you were working through an agency. And of course the agencies, they would charge people $69 an hour for
All
my
right, we
service.
probably better not get into those discrepancies.
but, you know,
it's pretty clear you do this for love, not
I do
money.
it for love. I don't do it for money.
Ms Bevan, can I focus your attention on the period 2015-2016?
Yes.
Do you recall where you were living during that period?
I was living in my house, which I'm still living in and paying off.
Okay. And I take it you were working during that period, Ms Bevan?
Yes, I was working.
Could Ms Bevan's statement be brought up? It's Exhibit 289. That's it. And could paragraph 9 be called out, please? So, Ms Bevan, in that paragraph you outline some of the three forms of employment you engaged in the 2015-2016 period, and you say that you, in the period 1 July 2015 and 30 November 2015, you engaged in employment with an entity named Care Agency Services Podiatry Limited.
That's right.
You recall
yes.
that? You then say that in the period 7 April 2016 and 30 June 2016, you were engaged in employment with Redland Respite Care Committee Incorporated. Do you recall that?
Yes.
And finally, you say that in the period 18 April 2016 to 30 June 2016,
Yes.
you were engaged in employment with a entity named Just Better Care Brisbane South Podiatry Limited. Do you recall that?
That's right. Yes, I was.
I'm going to ask you some questions in relation to those your employment with those employers. Do you recall whether you were employed on a casual, temporary or permanent basis with those employers?
I've actually never had a permanent job in my career. It's all casual. So it was all casual work.
Okay. And you've already given evidence in relation to the sort of income you earned in this area.
Yes.
Would I be right in saying that the income was quite low?
It was low. And that's really why I had to work more hours to pay the bills, kind of thing.
And whilst under the employ of those employers, were your hours consistent or?
Very inconsistent.
Okay. And I take it from your answer to that question that your income was also quite inconsistent.
It was very, very, very inconsistent.
And you've given evidence in relation to the types of client that you would deal with.
Yes.
Was it, in relation to those three particular employers, was it difficult work?
It was difficult work. I mean, I do love it, but it is very emotionally draining. I'm particularly in palliative care because I'm sure everybody can tell that I do get attached to my clients, and it is very sad when they pass away. So emotionally, on that side of it, it was difficult. Sometimes it's heavy lifting, you know, it's using hoists and things to move people around, to get them in and out of the showers, so it's physically demanding at times, and intellectually demanding, to looking at their needs and what I need to do and reading between the lines of what people are telling me. So it is quite a demanding job in that sense. And
Ms Bevan, can you explain, during that 2015-2016 period, can you give a brief description of your financial situation?
Well, I was just earning enough money just to get by. So there was no money to be put aside for savings. All my bills were paid fortnightly. you know, so there was no real money spare. I'd often go without food so that my kids could have more food. Like I wouldn't buy lunch or anything, or I just have breakfast and leftovers of what the boys didn't eat, which of course wasn't much by the time they were teenagers. So it was very hard going financially.
And Ms Bevan, were you accessing Centrelink benefits during the 2015-2016?
I was accessing partial payments.
And what was the nature of those Centrelink benefits that you were accessing?
They were a New Start allowance, and I think at that time I was still doing my degree, so I think I was getting some money for books and things from Centrelink. And the main thing was the healthcare card, which was what I really kept reporting my income for.
So you were accessing the New Start allowance to access a health card?
Healthcare card, yes, mainly.
Were there any other reasons as to why you were accessing?
And sometimes for that financial support on those weeks where I wasn't earning any money.
All right. Ms Bevan, whilst you were accessing that New Start allowance, did you understand that you were under any obligations in relation to the reporting of your income?
Yes, I was recording my income as I was doing the shifts, and then I was calculating my fortnightly income because I had to calculate all of those different employers, and they all paid at different rates, and shifts occurred at different times of the day, so that would mean I was paid at a different rate. So it was quite mathematical actually having to do it, and I had to allow a certain amount of time every fortnight to go through my diary, through all my shifts and calculate my gross income, and then I would report it
To Centrelink?
To Centrelink, and then a couple of days later I'd call up to make sure that that was recorded correctly.
Okay. And so I take it from that answer that the obligation was that you were required to report your income to Centrelink. And how often were you required to do that?
Well, I was doing that fortnightly, which was the requirement.
Okay.
And sometimes I would even add like $20 here just in case I'd made an error, or, you know, maybe they paid me more or something, you know, so I'd often over-report.
Okay.
I'd report a larger amount of money than what I actually earned just to cover that base of, you know.
All right. Could the following document please be brought up by the operator? It's Exhibit 2812. CTH dot, oh, there it is. Now, this is a letter dated the 11th of April of 2019, which is addressed to you, Ms Bevan, from the agency. Ms Bevan, do you recall receiving this letter at some point in 2019?
I do recall receiving it, but I'm not quite sure when I actually received it.
All right. Yeah.
But at that time, it was quite shocking to me.
And you'll see, just give me a moment. You'll see that in that letter, the agency says, quote, "We need to make sure that you receive the right amount of payments from us in the past. The Australian Taxation Office has given us information about how much income you earned from work in the past. The information from the ATO is different to the information you reported to us. We need your help to check and update your information. Later it says you have 28 days from when you receive this letter to update your information. And if we go over the page, under the heading past income information, you'll see that the agency outlines income amounts from those 3 employers we discussed earlier during the 2015-16 financial year. And you'll see there that in respect of care agency services, the information indicates that you earned a bit over $11,000.
Yes.
You'll see that in relation to Redland Respite Care Committee, it indicates that you earned over $5,000.
Yes.
And then in relation to Just Better Care Brisbane South, the earnings listed there in the amount of $2,637.
Yes.
Ms. Bevan, I'm particularly interested in the agency's statement in that letter that, quote, the information from the ATO is different to the information that you reported to us. That is, that the agency had identified some discrepancy between the income that you declared and the information from the ATO.
Yes.
In light of your earlier evidence that you believe that you're, in relation to your income reporting, did you have any understanding at that point as to how or why the discrepancy had been identified?
I had no idea. I knew that there had been some kind of error because I'd been so meticulously recording the information and reporting it to them and, double checking by phoning them as well. So I couldn't understand how they could have arrived at that conclusion. And, I was kind of racking my brain about that.
All right. And in the body of that, as I indicated before, in the body of that letter, the agency invites you to update your information within 28 days.
Yes.
Do you recall whether you updated your information within the 28-day period?
No, I was just too busy at that time, and I didn't think there would be any changes needed to be made because I recorded that accurately. At any rate, well, that's what my belief was.
Now, Ms. Bevan, I understand from your statement that you engaged in a number of telephone conversations with representatives of the agency throughout 2019.
Yes.
And is it the case that you've had an opportunity to listen to call recordings provided by Services Australia in preparing your statement?
Yes, I was able to listen to those recordings.
And you set out in your statement at paragraphs 22, 52, 57 and 59 a summary of some of the statements that were made in the course of those telephone calls.
Yes.
Could paragraph 22 of Ms. Bevan's statement please be brought up by the operator? And that's exhibit 2809. And you'll see there that paragraph 22 details a telephone call that occurred, again, between you and a representative of the agency. Do you see that?
Yes, I do. Yeah.
And I'm interested in the last two paragraphs, subparagraphs F and G of 22. The representative states what the department is asking you to do is to either use that Australian Taxation Office information for the review or provide bank statements and payslips to make sure that all that information is right?
Yes, well, some of that information I wasn't able to get because care agency services had...
I'll just interrupt you there. We'll get to that, Ms.
Yep.
Bevan.
Yes, so some of that information was unavailable to me.
And you, in response to the representative, say, when do you think I am going to have time? I cannot retrieve my pay slips from 4 years ago.
Yes,
You have my permission to go through the tax office
yes,
and do it that way.
yes.
Ms. Bevan, what was your understanding of the outcome of that conversation at the time?
At the time, well, I thought they were going to be using the tax information to work out my, fortnightly rate.
Okay.
That's what I thought. And I thought through that process that they would see that an error had been made.
Okay.
But I was very upset at the time that I received that call, and I did feel like I was being treated as a criminal, like I had been fraudulent, which I went to great lengths not to be.
And so essentially, was it your understanding that the agency would be assessing whether you had been overpaid
Yes.
on the basis of the information that the agency had received from the ATO? Is that right?
That was what I thought.
Okay.
At the time, that's what I thought.
All right.
And I thought somehow that would correspond with my own recordings of the information. I don't know why I thought that. But
And do you feel you had a understanding of how that would be done, of how that process would be undertaken? by
no,
the
I had no
agency?
idea.
Okay. Would the following document please be brought up by the operator? It's Exhibit 2814. Thank you. Ms. Bevan, this is a letter dated the 22nd of May of 2019, addressed to you by the agency.
Yep.
Do you recall receiving this letter at some time in 2019?
I didn't receive this letter.
Okay. But I take it that in your preparation for giving evidence in this Royal Commission,
I did
you've
read
been
it.
shown a copy.
I did read it, and the information on there about my earnings is correct, but the information about my reporting is incorrect.
And though you don't recall specifically receiving this letter,
Yeah.
am I right in saying that you recall at some point in 2019 becoming aware that a debt in the amount of $2,951.35 had been raised against you?
Yes, I was made aware of that.
In relation to that letter, you'll see, Ms. Bevan, that letter says, "We have finished checking your past income." It goes on to say, "Our records show you did not check and update your information or ask for more time by the due date. We have used the information we had from the Australian Taxation Office to assess the amount of payments you have received from us in the past."
Yep.
And under the heading, "What that means for you," you see there that indicates the amount of employment income you reported to the agency was $7,603.
Yes.
The second point there is the amount of employment income reported to us or the agency should have been a bit under $12,000.
Yes, yes.
And finally you see at the bottom of that text box the amount you owe us, brackets, including a 10% recovery fee, was $2,951.35.
Yes.
Now, Ms. Bevan, what was your, and I'm conscious that you don't recall specifically receiving this letter, but what was your reaction? Do you recall what your reaction was when you first found out that a debt in that amount had been raised against you?
Well, I was really shocked, and I was really angry that this had occurred, and I knew that something had gone wrong. I went and got all my old work diaries, which I still have them actually, and went through them all, and my figures were not matching up with their figures, and I was really upset. I was really upset, and the tone of the letters upset me. It was just, it was very shocking to me, and it really angered me that I was being kind of treated in this way.
All right. Ms. Bevan, do you recall your financial position at the time the debt was raised, around in mid-2019?
Well, it was just as it had been for a long time, just going from paycheck to paycheck really, and just trying to manage my money around there. So they may as well have been asking for $1 million really, that I couldn't have paid that amount. But I had no intention of paying it because I felt that there was an error, and I was determined to find out what that could have been.
All right. And just to be clear, where were you working at the time in mid-2019?
2019, I was working just with one company, with Higher Up, and I was also doing some private work, and I was also setting up, seeing some counselling clients as well. So I was sort of juggling a lot of things.
And I take it that all that work was still in the disability aged care sector?
Yes, yeah, most of it. It was mostly there, and the counselling work I was kind of doing for free. Some of it was for free, and some of it I was getting paid a very small amount of money.
Thank you. Could the operator please bring up paragraph 31 of Ms. Bevan's statement? That's Exhibit 2809. Thank you. Ms. Bevan, in that paragraph you describe a telephone conversation or conversations that you say you engaged in with representatives of the agency after receiving the debt notice.
Well,
Am I right in saying that you don't have an independent recollection of the specific dates of those conversations?
I don't have a specific recollection of those specific dates.
But you understand the general thrust of many of those conversations?
Yes, I do. And, I became aware that I had to sort of provide more information.
Okay. And so if you say there that you understood the outcome of your conversations with the representatives of the agency to be that, firstly, your debt would be reassessed by the agency. Is that right? Do you recall that?
Yes, I thought that I was going to provide them with this information, the bank statements, and my diary entries, photocopies of my diary entries, and they were going to reassess that based on that information.
Okay. And you've just covered subparagraph B there.
Yep.
You understood, didn't you, that you were required to provide to the agency records
Yes,
for the purposes of that reassessment.
that's right. And I tried to contact these former employers about the pay slips, which were not available to me. And of course, Redland Bay Respite Centre had been taken over by another organisation and there were no pay slips. Just Better Care was a franchisee type of arrangement and there was a new person who had taken over the franchiseeship of Just Better Care and there was no real records of the time that I spent there, only partial records, and Care Agency Services had written me a letter confirming what I'd earned.
Okay. So I take it from that evidence that you experienced some difficulties.
A lot.
Some difficulties in obtaining records from your former employers, is that right?
Yes, it took a lot of time and it was very difficult and impossible, as it turned out in the end, to get full details from that long ago.
Right. And can you explain to the Commission a bit about the impact that the effluxion of time had on your ability to obtain those, noting that you were being asked to retrieve these records in 2019.
Yes. Yeah.
And in relation to your employment in 2015, 2016, can you explain to the Commission a bit the effect that the effluxion of time had?
Well, it took a lot of time for me to be making these calls and chasing up these people. Like Just Better Care had a different telephone number. I had to call the head office to find out who the franchisee was, and you know, the Just Better Care had changed computer systems, so they had no record. Care Agency Services. So it was just an impossibility. A lot of the people that were working in those organisations that could have helped me weren't working there anymore. And Care Agency Services was taken over by somebody else. Redland Bay's Respite Centre was defunct and their clients were taken up by another organisation. So it was just hellish. And the only real evidence I had was those diary entries and the bank statements. The bank statements were going to cost 10 cents per page, and I had two different accounts, like a savings account. Because by this stage I was earning enough money to save money, but I had two different accounts that I had to access and photocopy all of the diary entries, which was difficult in itself because they were old. The diaries themselves were old and there were things written in the diary like the day my cat died, and you know, there were just it was just a bit of a mess. Right. And but I was able to do that. And at the time I thought it was strange that they only wanted a specific time frame of the year, not the whole year, of my diary entries, and I just kept sending them the whole year. And
so I take it from you sent those records that you described, or those partial records that you described, to the agency on a number of occasions, is that right?
I did. I tried to upload them, take photos of the diary entries and upload them into the system, but the amount of diary entries that I was uploading, it just said that too much data, so I had to call them about that. You know, it's just, and then, anyway, we'll get to that probably.
All right. And can I take you to paragraph 38 of your statement? And I'm particularly interested, Ms Bevan, in the second last sentence in that paragraph where you say you felt that the onus was on you
Yes.
to prove that you had not done the wrong thing. Can you speak to that?
I felt like I'd been found guilty of this thing, fraudulently claiming benefits, and I had to prove my innocence in this case. And I was spending a lot of time trying to do that, time that I could have been spent with my family, doing things with my family, or working.
Okay.
So,
All right. Would the following document please be brought up? It's Exhibit 2826. Now, Ms Bevan, is it the case that this is a letter from you to the agency dated the 4th of July of 2019?
yes.
Do you recall providing this letter to the agency?
Yes, I do recall
And
providing that information.
do you recall how you provided this letter to the agency?
I emailed that to them after I'd had a discussion with my dad. Yeah.
And Ms Bevan, I'm interested, so one moment. In that letter, you say, quote, "It has been found that I have been overpaid. The calculation used has been based on a segment of the tax year 2015-2016. It occurred to me that this has been done using the assumption that I was paid a regular weekly income. However, at the time in question, I was working with a nursing agency that provided emergency relief staff, to other organisations throughout Brisbane. There would be some weeks where I got $1,000 a fortnight and other pay periods in which I was paid as little as $200 a fortnight. This was the main reason I was receiving government payments."
Yes.
You go on to say, "I always reported my income and added $20 in case I was overpaid. My true income over the entire year was approximately $211 a week. Surely this would allow me to receive some money from the government." Now, Ms Bevan, I'm interested in two features of your letter. The first is your statement that the agency was using, quote, the assumption that I was paid a regular weekly income. That's the first feature. The second feature I'm interested in is your assertions that essentially your income varied from fortnight to fortnight.
Yes.
Why did you consider those two matters to be an issue?
Well, as I said earlier, I was trying to give them the whole year's information, and they were only accepting a portion of that year. So I knew there was something wrong with that. And then I thought they must be, and I had a discussion with my dad about it, and I figured that they must have been averaging my income. So I worked out the calculations there of what the average was.
And so you say that you understood that you were under an understanding that they were averaging your income. And why was that an issue in your case?
Because I thought, and I actually wrote the email thinking that perhaps they didn't understand the nature of casual employment, and that sometimes there was a lot of work and sometimes there wasn't any work, and that averaging would be an inaccurate way of describing my actual income.
All right. Now, do you recall whether you received any response to the substance of that letter?
No, I didn't receive a response.
Would the following document please be brought up? Exhibit 2821. Thank you. Now, Ms. Bevan, this is a letter dated 17 September of 2019,
Yes,
addressed to you from the agency. Do you recognise that letter?
I do.
And do you recall receiving this letter at some point in 2019?
Yes, I do.
Now, the letter reads, "We are writing to you about your request for a reassessment of debt ID, redacted, made on 3 July 2019. It says, a reassessment has been undertaken of that debt
Yes.
for the amount of $2,951.35 for the period 11 July 2015 to 28 April 2016, which has resulted in a change to the original debt outcome. The original debt of $2,951.35 has been amended to $1,328.80. Now, what was your reaction, Ms. Bevan, to finding out that your debt had been, as a result of the reassessment we spoke about earlier, what was your reaction to finding out that the debt had been reduced?
Well, it had been reduced, but as you can see, it still wasn't based on the full year income, being from the pay period, the 10th of July to the 28th of April. So I still felt that there was something wrong with this assessment.
And did you understand, having read that letter, the basis upon which, or the process through which the agency undertook to calculate the amended debt?
Well, this is confirmation, isn't it, that they were using averaging. But yeah, I mean, I was just more angry and more frustrated and still felt like I was being treated like a criminal.
Okay. And so am I right in saying that just from reading that letter, it was still unclear to you?
I still really wasn't understanding, and I still actually don't understand how they arrived at that amount. I still don't understand how they did it. I knew that it was some kind of averaging, but I didn't know. And I kind of understood that it was on a segment of the year, not the full year, but I didn't really properly understand how they'd arrived at this information.
All right.
Or this conclusion, I should say.
Now, Ms. Bevan, did you at any time pay off any amount of that debt?
No, I was pretty adamant that I wasn't going to do that because I felt that they'd made an error and it was not my responsibility to correct their error. That I had done what was legally required of me to tell them what I earned every fortnight accurately, which is what I did. And I felt that whatever they were doing at that end was dodgy, and I was not going to be paying my hard-earned money to them.
All right. And Ms. Bevan, I think you said before that you'd had a number of telephone conversations with representatives of the agency.
Yeah.
Can you describe briefly, well, firstly, on how many occasions do you think that you were called by the agency in relation to these debts?
At the time, it felt like they were calling me quite a lot, and at varying different times of the day. And I would often be driving in between shifts, and you know, it was just a real intrusion into my work, you know, for one. But I was always trying to be polite to them. I was always trying to assert my position. But I just felt that everything I said was falling on deaf ears. They weren't hearing me. They didn't acknowledge that letter that I sent them. And, you know, it was just awful. And there were some times where those conversations, I would be getting off the phone and I was shaking. One in particular and we heard it in the office, where they were barking at me like, you earned $1,600 and you got paid, and, you know, and they were just really blaming and viciously attacking me. And as much as I said, yes, I got paid $1,600 for that fortnight, but the next fortnight I didn't earn anything. And that I did record that information as best as, you know, in a way that was legally required of me. But I would get off the phone, I'd be shaking. And there was one time that I was driving home, I was so upset, I was so sleep deprived at the time because of the hours that I was working sometimes, but also I couldn't sleep because I was going to bed at night and racking my brain trying to figure out what had happened and, you know, what was going to happen. How were they going to get this money from me? And there was these threats of taking money directly out of my pay or out of my bank account from my tax return. And it was just such a weight on my shoulders. But I do remember driving home at night just beside myself with worry about this money, and thinking I could just drive my car into a tree and make it stop. But, sorry.
Do you need a minute? Would you like a little break?
My kids needed me. They'd already lost their dad. And I was trying my best to keep my house, the roof over our head. I was working so hard and going into every shift, trying to be cheerful and happy for my clients because I didn't want to let on to them that this was happening to me. It was just a really horrible time. And it was just made worse by this constant accusations of me apparently doing the wrong thing when I went to such lengths to do the right thing. And I mean, I was just really devastated by it because, I mean, I was trying my hardest in life, just generally, to be a good person, to be a contributing person to society. And this robo-debt, this debt that was over my head, which I knew was wrong, was just the straw that was breaking my back. I would dread it when the phone rang.
in case it was them being rude to me, being dismissive of me, not hearing me, and treating me like a criminal. Sorry,
Miss Bevan, if you need a moment, Miss Bevan,
I'm okay.
you're okay. Do you recall? Do you recall at some point in 2019 your debt, or what was the end result of your debt? I understand that your debt was wiped at some
My
point?
debt was wiped.
Could Exhibit 2832 be brought up by the operator, please? So, Ms. Bevan, this is a letter dated 31 July of 2020, sorry. And it's addressed to you, and it says, your income compliance debt has been changed to zero. Centrelink has changed how we use employment income information from the Australian Taxation Office in income compliance reviews. You previously had debts raised using averaging of ATO information. We no longer do this. The debts below have been changed to zero. Our records show that you have not made any repayments towards your income compliance debts. This means there is no refund to be paid. All unpaid debts raised using averaging of ATO information have been changed to zero. Now, Ms. Bevan, do you recall receiving that letter?
Yes.
And what was your reaction to finding out that your debt had been wiped?
Well, I was relieved, of course, that the debt had been removed, that they had found that there was no debt after all. I was pretty frustrated, angry that they'd put me through this months and months of literal torture to try and receive this 1,300 or 2,900, and I think at one point it went up to 3,000. I was very angry that they put me through this and put my kids through this and made my life so difficult, to then eventually for it to be found that I was right in the very beginning, that I didn't owe them anything.
All right. So, where has this experience left you, Miss Bevan, in terms of your views on accessing Centrelink benefits in the future?
I will never access Centrelink benefits ever again. My son, when he left school, was eligible for New Start allowance, and because of this experience, and this affected my kids as well, we didn't apply. So I then continued to support him until he recently got a job with his brother as a scaffolder, which is a hard job to do. And he could have we tried to access some training for him, but in order to access the training, you had to have a New Start benefit, and we weren't going to be doing that.
All right. Commissioner, I have no further questions.
Ms Hogan-Doran?
Ms. Bevan, thank you for your evidence. I don't have any questions for you.
Thank you.
Thanks very much, Ms Bevan. You're excused. Thank you for your time today. I have one small point for you, Mr Freeburn. It doesn't involve Ms Bevan, so you can be disconnected, so to speak. And the small point for you, Mr Freeburn, is I have this exhibit which is part of the Ilion file, response to notice to give a statement, and then annexures to the statement of Mr. Ross.
Yes.
It seems to contain about 190 redacted pages. I'm not receiving them.
Okay. Right.
So it can just be the annexures to the statement of Christopher John Ross, the page that says the annexure with document ID, MGR, so on, is produced as a separate file. But I think we've got enough in the way of exhibits without including 190 redacted pages, which I assume were redacted because they had absolutely nothing to do with Ms. Bevan.
That's correct.
Thanks.
Thank you, Your Honour. Commissioner.
Yes, Ms. Berry, you're... Jess, is there another? Thank you. Thanks. Yes, Ms. Berry.
Thank you, Commissioner. I appear for the next witnesses with Mr. Freeburn.
Is your microphone on and is it undamaged?
Is that better?
Seems to be okay, I think. Yes.
Commissioner, the next two witnesses are Dr. Goldie and Ms. Crowe from the Australian Council of Social Service, who will each give evidence as part of a panel.
Right. Now, I'll start with you, Dr. Goldie. Would you prefer to take an oath or an affirmation? All right. Would you mind standing and we'll do that?
Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
Thank you for that. And Ms. Crowe, what's your position?
An affirmation, please.
Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes, Ms. Berry.
Thank you, Commissioner. Dr. Goldie, can you tell the Commission your full name and the role in which you are giving evidence today?
I'm Cassandra Goldie, and I'm the Chief Executive Officer of the Australian Council of Social Service.
And Ms. Crowe, can you also tell the Commission your full name and the role in which you're giving evidence today?
Charmaine Lindy Crowe. I'm the Program Director of Social Security at ACOS.
And Dr. Goldie, is it correct you received a notice on behalf of ACOS to give a statement and produce documents to the Commission?
That's correct.
And you have provided a statement in response to that notice and along with accompanying documents. And Dr. Goldie, are the contents of your statement true and correct to the best of your knowledge and belief?
Yes, they are.
Thank you. Commissioner, I tender that statement and the associated documents, and I understand that in the index that you've been provided with, the exhibit numbers for those documents will be 2840 to 3145.
Right. The documents bearing those numbers will be admitted as exhibits with the numbers recorded in the schedule. Thank you.
Thank you, Commissioner. Dr. Goldie, I'll start with you. Can you please give the Commission an outline of what your role as the Chief Executive Officer of ACOS involves?
ACOS is national voice for the experience of people on low incomes facing poverty and inequality and other disadvantage. And we're also the peak body for the community sector. We have a large number of community organisations who are our members, as well as our state and territory councils of social service. Large number of our organisations also represent people on very low incomes.
And Ms Crowe, are you able to outline the expertise or experience of ACOS with respect to social security policy and advocacy?
So ACOS has extensive expertise in the social security policy as it relates to reducing poverty and inequality in Australia. And so we've developed this policy expertise across a range of areas, including adequacy of income support payments, income support payment settings like income tests and asset tests, debt recovery and that kind of thing. And of course, we do extensive research in social security legislation and policy, as well as engage with government, bureaucrats and other stakeholders on income support policy, and of course with people directly affected, as well as our member and other organisations and academics who are experts in the field.
Right. And Ms Crowe, I'll take you first of all, if the statement could be brought up, please. It's ACS.999.0001.0308 _R. Which is Exhibit 2841. Can I just check that that is the redacted version? Just a signature at the end. So, Ms Crowe, in your statement, particularly at paragraph 24, you firstly talk about your experience with people who were affected by the Robodebt scheme. Can you tell the Commission what your experience was in terms of the types of social security payments that people were receiving?
The Robodebt primarily affected people receiving New Start allowance, which is now the job seeker payment, and student payments like Youth Allowance Student, Austudy, etc. But it also affected people receiving pension payments like the age pension, disability support pension, carer payment, and of course the parenting payment.
And then, as we can see on the screen here, you give in the statement an outline of the nature and types of some of the vulnerabilities that you've observed in many of the people who were affected by the Robodebt scheme. Are you able to take us through some of your observation with respect to those vulnerabilities?
Yeah, so by definition, people receiving income support typically have very low incomes and assets, and they are typically in a state of financial stress. And we also know that there is a higher instance of people having disability or chronic health conditions. Of course, people are often at risk of homelessness or are indeed homeless. People may come into the income support system typically at times of crisis. So they may be experiencing domestic violence, they may have suffered a bereavement, they may be going through a relationship separation. We know that there are higher incidents of people living in regional, rural and remote areas of Australia, typically low income areas of Australia. And some may have been through a natural disaster and come into the income support system that way. And
are there particular characteristics that you would say are common to the employment patterns or earnings patterns of people on income support payments?
In our experience, it is very common for people, particularly receiving working age payments like job seeker, to have sporadic earnings, if any. The majority of people don't report earnings in the previous fortnight, but where they do, it's often from casual paid work, or it might be episodic in nature. And so in one fortnight they may not earn anything, in another they may earn some income. And indeed, the social security system is set up in a way that recognises that by having things like an income bank or working credit system, where if you don't earn anything in one fortnight, you may be able to earn more or above the income-free threshold and not have your income support payment reduced as a result.
So that's the income bank credit that...
It's called the income bank for student payments and the working credit system, if you like, for a job seeker.
And if we could please have up the next paragraph, paragraph 25 of the statement. What you were just speaking about there, those patterns of earnings in social security recipients, you refer to that there in paragraph 25, and you say a scheme...
Ms. Berry, I'm sorry, whose statement is this?
It's Dr. Goldie's, sorry.
Yeah,
Yes.
and so, sorry, whom are you questioning now?
Sorry, I'm addressing my question to Ms. Crowe. I might rephrase that to say in paragraph 25 of this statement, it talks there about the use of averaging, and it mentions that that could inevitably lead to inaccuracies in the assessments of overpayments and debt. Are you able to speak to what is generally meant there by averaging of income?
Our understanding of averaging would be that someone's earnings that have accrued over a 12-month period would be divided by 26 fortnights in the year, and that amount would be applied against their income support payment to determine whether or not they had been paid the correct amount.
And so we're talking about, is it correct that we're talking about fortnightly amounts there because, as you've observed in your evidence and as the statement says, social security payments are assessed on income earned over a fortnightly period?
Correct.
So could I also just ask you to comment, the statement specifically mentions averaging of income over a 12-month time frame, inevitably leading to inaccuracies. Would, in your view, would the use of averaging over a shorter period of time, perhaps of less than a year, still lead to similar inaccuracies?
Yes, it would.
And why is that?
Because you would not be making the assessment on the fortnightly income earned for the relevant fortnight that the person received the income support payment.
And so is what you're saying there that, for example, the example you gave before of the income bank credits, that if somebody earned a particular amount in one fortnight and then nothing for the next 2 fortnights, averaging of that income may result in inaccuracies in a calculation with respect to each of those individual fortnights.
That's right.
Under a social security means test method.
So you really can't even safely average two sets of fortnights in a row?
Only if the income that was earned was exactly the same.
In which case you wouldn't really need to be averaging.
Correct.
Thank you.
That also doesn't factor in a working credit or an income bank, but assuming that didn't apply. But, yeah.
So I'll turn back to paragraph 28 of the statement, and I'll stay with you for the moment, Ms. Crowe. Can you tell the Commission what you observed to be the effect of Robodebt on people who were impacted by the scheme?
So Robodebt undoubtedly caused a huge amount of stress for people who had received the debt notices. It also took people a lot of time engaging with Centrelink to firstly try and figure out what was going on through to trying to clear their name. We know that the many people suffered severe distress from receiving a Robodebt. The fact that people had to go back up to 6 years to try and find pay slips or evidence of their income that they most likely reported at the time was extremely difficult for people and stressful in and of itself. We heard from people who had health conditions that were aggravated by the mere receipt of a Robodebt and dealing with the issue. People had to take time off work to deal with it. It caused stress within families because of the fact that people had received the debt. People hid it from their partners because they experienced shame. And, you know, we know that it caused, it caused mental health issues for a lot of people just because, you know, it was an awful thing to go through. And people felt very powerless to try and clear their name because they couldn't get the information that they needed. And they felt helpless. This was a government that had applied the debt, and there's definitely a power imbalance there.
So, taking that concept of the power imbalance, Dr. Goldie, I might ask you my next question. At paragraph 30 and this is your statement, you make the remark that ACOS was deeply concerned about what you've described as a climate of fear on people who were on social security payments. Are you able to elaborate on what you mean by that concept?
Yes. Recall there was a May 2014 budget handed down by the then Abbott government, which was widely known to be a horror budget. It was most horrific for people on low incomes. Already at that point, they were trying to pursue about 19 billion in cuts associated with a range of social security and other measures that would be helping people on low incomes. And then in May 2015, there were further measures added to that. And so by the time you get into 2017, I've listed in our statement the range of kinds of cuts that were being pursued, taking relief away from people who desperately needed it, including single parents with a number of children who were in abject poverty. And then overlaying that, you had a government that was using language about being a welfare cop, using language about we will come after you, using language about we will find you and track you down, and if you don't pay, you might end up in jail. And so this notion of the Department of Human Services, or Centrelink, being there to help people was the complete opposite of what the government was actually communicating. For people on very low incomes relying on income support, what they heard was this is a dangerous place to come. You won't be safe. And so we were very, very worried about the rhetoric that was being used. We had, for example, in November 2016, we expressed our alarm about the use of letters which had the Australian Federal Police logo attached to a Centrelink piece of correspondence being sent to people where there was no indication that they had committed any kind of welfare fraud at all, and yet the police logo was on the correspondence from the Department of Human Services. And then we had the minister responsible at the time in December 2016 in the media, as I say, and I quote, "We'll track you down and you will have to repay those debts and you may end up in prison." And I said into the media then, it is appalling that the Minister for Human Services is telling people on the lowest incomes 3 weeks before Christmas that if they have a debt with Centrelink, they may go to prison. This is false, it's highly irresponsible and risks causing a huge amount of unnecessary distress. We are not a police state. But that's what was being communicated in our clear view, and we had many occasions where people were providing that kind of feedback to us that that's how they felt even having any contact with Centrelink to even apply for income support.
I might take up your comments there about that article and the comments that were made in early December 2016 by the then Human Services Minister. Can we please bring up document ACS.999.0001.0309? That is Exhibit 3137. So, Dr. Goldie, if I can just ask you, if you can see under the title and then the byline, the name Christopher Naus is the journalist.
Yes, that's correct.
And it's quite small print, but you can see there that the article was published on the 7th of December 2016.
That's correct.
And then it's up in the very top line, you can see that it was published by the Guardian newspaper. And I believe that's a photograph of yourself there. Is that the article that you've referred to in your statement, identifying those comments? So if we just have a look there at that article in the, if we can draw out please the third and fourth paragraphs, and you can see there the words spoken on a current affair. We'll find you, we'll track you down, and you will have to repay those debts and you may end up in prison. Are those the comments you were referring to before?
Yes, they are.
And then if we go over to the second page, please. Dr. Goldie, your comments in response are set out in the 3 paragraphs just above the middle box. And I think you've taken the Commission through those in essence.
Can I just interject? I think in fairness to Mr Tudge, he says that he said those things in the context of fraud. Does that make, I don't know what your response is to that or whether that makes any difference to your perception of the statements? Dr Goldie?
It's the climate that's being created around being involved in Centrelink. So a lot of the media reports were mixing up welfare fraud with overpayments, and many of the measures that were being talked about also, it was unclear whether the government was actually talking about welfare fraud or overpayments. And as we hear, people who are receiving income support would feel like they were being accused of doing the wrong thing because they were being told through this scheme, you have failed to report accurately your income, even when they're going, we've done everything that we were meant to do. So this is about the climate that's being created, a sense of it being unsafe, that you could end up in jail. This is about people not really knowing what actually is the difference between welfare fraud and overpayments and whether or not they are being accused of defrauding the Commonwealth.
Thank you, Commissioner. You had anticipated my next question. Thank you, Commissioner. Which really was that, and you possibly already answered this then, but that if that comment is in the context specifically directed towards fraudulent activity as opposed to inadvertent overpayments, was that context clear to you at the time this comment was made?
It was not clear to me.
And you may not be able to answer this, but are you able to comment on whether, in your experience dealing with income support recipients, there was an awareness generally of an understanding of the distinction between comments that were being made in relation to serious fraudulent activity and comments that were being made in relation to inadvertent overpayments?
I think it's very accurate to say that people often feel very confused about whether or not they're being accused of something that's criminal when they're dealing with Centrelink, and this kind of comment was fueling that kind of confusion.
Yeah. It was common at the time for the government's commentary about welfare fraud to be conflated with overpayments. It was rare that government would distinguish between cases of serious fraud and overpayments, which was obviously a much more common occurrence because of the difficulty in reporting income fortnight to fortnight, because people would often need to estimate what their earnings were because their pay slips wouldn't marry up with the fortnight in which they were receiving the income support payment.
And can I just pick up on your point there, Ms Crowe? Are you talking there about what might generically be called a Centrelink fortnight, which was the fortnight across which Centrelink would assess your eligibility for payment, and then somebody else's work fortnight, and that those two periods might not necessarily align perfectly?
Correct.
And just before we move on through December 2016, Dr. Goldie, if I can just take you back to the period in early 2015. So this was prior to the release of the budget in May 2015. Are you able, do you recall meeting with Minister Morrison in his capacity as Social Services Minister?
Yes, I do.
Do you recall when that was?
Yes, on the 20th of January
Yes.
of 2015.
2015.
Yes.
And do you recall what was discussed in that meeting?
Yes, we discussed proposed welfare reforms generally. We also expressed our deep concern about the previous budget, the May 2014 HORI budget. He had recently been appointed Minister for Social Services, and so we were urging him to revisit the savage cuts that were put into that budget, and we discussed those kinds of issues.
And do you recall any further meetings in the early 2015 period with Minister Morrison?
Yes, there was a further meeting with Mr Morrison on the 8th of April, which my colleagues attended. I was not at that meeting.
And Ms Crowe, I understand you weren't in the organisation at this particular point in time.
No.
So, Dr Goldie, even though you weren't present, did you receive any reports of what was discussed in that meeting?
We don't have a record of what was discussed in that meeting that we can locate at this time.
And do you have any memory at all of somebody?
What I can say is that in the many conversations that would have occurred, there was no discussion about this scheme.
And you mean the Robodebt scheme?
Yes.
And in terms of the meeting that you attended in January, did you raise the concept of income averaging with Minister Morrison? No. And why is that?
Because we were not aware of the plan for this scheme to be introduced.
And so am I correct in saying that you really had no reason to raise that as a concept because at that point you were unfamiliar with what the plan for what ultimately became Robodebt was?
Yes, I mean, we couldn't raise concerns about something that we didn't know about.
I'm paraphrasing a little, but Mr. Morrison's evidence was that averaging was a pretty standard practice, well known around the place, and that you said nothing about it, or you and other stakeholders. Can you comment on that?
I'll invite my colleague to lay out our understanding of how those income averaging was being used at that time.
So our understanding is, at least prior to Robodebt, was that if averaging was used, there had to be a person making the assessment. There had to be a person involved. You couldn't just average the income out over 12 months and then raise a debt on that basis. I recall seeing the operational handbook at the time, and it very clearly spelt out that if a decision maker was to rely on averaging, there was a high risk of it resulting in an inaccurate debt assessment, and that every step had to be made to seek other evidence before relying on averaging in and of itself.
Right. Dr. Goldie, I assume if averaging were a common feature, you'd be hearing about it from your constituency. Did you?
No.
All right, so it just wasn't something on your horizon, on your radar.
No.
All right, thank you.
Thank you, Commissioner. Dr. Goldie, I'll take you back then to that period in late 2016. In paragraph 40 of your statement, is it correct that that later period in 2016 is when you and ACOS became aware of Robodebt?
Yes, that's correct.
And how did you become aware of Robodebt? What sort of things were you hearing?
We were being approached by journalists. We were hearing from people directly affected. We were hearing from organisations that are members all over the country, expressing their alarm about people coming with these kinds of debts and saying that they didn't know them.
So did you make any contact with ministers' offices at that time?
Yes, so we firstly attempted to get more information from Minister Porter's office, and I met with one of his members of staff, I think in December, but he didn't have any information about what was to be known as Robodebt.
And was there a reason why you approached Minister Porter's office first?
We had a contact with his office at that time as an organisation, and we thought, well, we'll see if they can provide more information at that stage. But when we weren't able to get information, then we made contact with Minister Tudge's office.
And that was, is it correct that your communication was with a Mr. Mark Wood, who was the senior advisor to Minister Tudge?
Can I just go back? You contacted somebody in Minister Porter's office who didn't have information. Did he just not know about this scheme?
Just didn't know. That was my impression from the meeting.
All right.
Didn't know.
Thank you, Commissioner. And so what did you raise with Mr. Wood at that point in time?
So we were concerned about people coming to us saying that a debt had been raised against them and it was inaccurate. And so we were trying to get to the bottom of how this could be happening and just basically seeking more information about Robodebt. Mr. Wood then provided some example letters to us that people were receiving and provided a little bit of information about the scheme in that people were asked to go online and correct their record as a result of receiving the first notice from Centrelink.
And you then, is this correct, Dr. Goldie sent a letter to Minister Tudge in
Yes, that's correct.
mid-December. If we could please bring up Exhibit 3013. And Dr. Goldie, you'll see there it's a letter from ACOS dated 21 December 2016, and it's addressed to Minister Alan Tudge. And if we could please just flick over to page 4, which is the last page. You'll see there, Dr. Goldie, that it is signed by you. Do you recognise that as the letter that you sent to Minister Tudge on the 21st of December 2016?
Yes.
And so if we can go back to the first page, please. Dr. Goldie, we can go through some of these items, but generally in that letter, would you agree that you set out a number of your concerns at the time as to what was happening under the Robodebt scheme?
Yes, that's correct.
So we'll just start with, if we could draw out the paragraph numbered 1. And Dr. Goldie, are you able just to briefly outline your concern that you've expressed in that paragraph there?
Well, this was the heart of the most serious flaw in the whole program, which was the use of the income averaging to generate the actual debt and to pursue that debt against somebody. So we knew, because of the kind of work patterns that people had, all of our experience, that would be inevitable that people were being pursued for debts that would be inaccurate or that they didn't owe. And we were very, very alarmed by that.
And if that could be taken down and paragraph 2 drawn out. Dr. Goldie, you've also identified a concern there in terms of the imposition of a 10% recovery fee. Are you able to explain what your concern was there, Ms. Crowe?
So we had understood at the time that people were being charged the 10% recovery fee without any engagement with a person at Centrelink. And to our mind at the time, we were concerned about that because Centrelink can only apply the 10% recovery fee if they can determine that the person knowingly or recklessly failed to report their earnings when they were receiving the income support payment. So we were very concerned about that because our understanding was that the 10% recovery fee was not being applied in accordance with the legislation.
So am I right in saying that it was your experience at the time that it was being applied in a large number of cases?
Yes, we had heard from people who had had the 10% recovery fee applied, including people who had first found out about their Robodebt from a debt collector because they hadn't actually received the notices.
And if we could just go to page 2 and call out the paragraph of item 3. Are you able to make some comment about the difficulties that were being experienced by people having to retrieve records from quite a long time ago?
I think anyone would struggle to pull up pay slips from up to 6 years ago, particularly before pay slips were typically emailed to people, and that was a common occurrence, and so people just simply didn't have them. Also bear in mind at the time, Centrelink's advice to income support recipients was to retain their pay slips for a period of 6 months, not 6 years. And at this time, Centrelink was not accepting bank statements as evidence of earnings for any particular period. And so people really had to rely on their pay slips. People often had difficulty going to previous employers to get pay slips. And of course, individuals don't have the powers that Centrelink does in that Centrelink has the power to request this kind of information from an employer which is not a power that an individual citizen has. So there are a range of problems with this program.
And if we can then draw that down and pull out item 4. You note there, as is in the statement, the difficulties that that many income support recipients had on accessing an online system. Are you able to speak to the experiences that you had awareness of people having those sorts of difficulties?
Yeah, so it was a consistent complaint to us that they could not access the online portal. People also had difficulty accessing MyGov. They needed to use, their password wouldn't work, and then they couldn't get through to update their password, and so on. People had trouble uploading documents that would provide the evidence that Centrelink was requesting, but they simply couldn't do it. We also heard of people going to Centrelink offices to do it face-to-face or prove their earnings face-to-face and being told to go and do it via the online system. And of course, this assumes that people have online access, which many people don't. Many people can't even afford an internet access. And of course, people in rural and regional areas often have difficulty accessing online services. So the fact that people had to do this online, there was a raft of problems with that because many people simply were unable to do so.
And if we could pull 4 back, please. I think, Ms. Crowe, you really have addressed also the point that's raised in item 5, where you spoke about that you'd had reports of people who had been trying to attend, or did you have people also trying to call who were redirected online, or?
Yes, well, at this stage, there was no dedicated phone number for Robodebt. And so when people received the letter, they didn't have a phone number to call. And so it had to go on a bit of a fishing expedition to see who to speak to within Centrelink. It's difficult in and of itself. And often when you call other phone lines that Centrelink send, there are long wait times. And so people were having to spend hours on the phone just to get through to someone who may or may not be able to help them.
And then at items 6, 7 and 8, which you have also included in this letter, Dr. Goldie, you outline your concerns about the collection of debts under the process. And if we could just call out paragraph 6, is it correct there that you make the point there that mail may not be reaching people? That's in the middle sentence, considering that contact by mail may not reach people because they have moved. So did you have reports of people who hadn't even received their initial letters or debt letters?
Yes, we did. It was that the first time people knew that there was any problem was when they had a debt collector suing them. And of course, because this scheme was going back so far, you could really safely assume that many people would have moved, would have changed address. And so the need to make personal contact was even more important. And of course, if a debt collector can locate you, then surely the department could have instead.
It was absurd that Centrelink was using the last known address of people no longer in the income support system as the sole means of sending them a letter. And obviously a lot of people would have moved address in that time. And so that's why many people first found out about the Robodebt was via a debt collector.
And so I think that really addresses item 8 in that letter, And just with respect to item 7, the point, is it correct that the point you raise there was the timing and the scale of the collection of debts? Are you able to speak to what you're addressing in that paragraph?
Yes, well, our understanding is it was 20,000 per week.
Letters were...
Letters being pursued without any notice to any organisations that might actually have been able to help people. This just happened. And as I say, our evidence is that the first time we heard about it was when people started to come to try and get help. And the scale of this was unprecedented.
And in terms of timing, you make reference there to, at that point in the year, this letter being the 19th of December, it was quite close to Christmas. And is it correct that the point you're making there is that there will be limited access to perhaps not only Centrelink itself, but also to organisations that people receiving these letters might need to access at the time? Is that correct?
Yes, it is. I mean, of course, as our evidence is clear, we were deeply concerned about the design of this scheme, but for this to be unleashed at this time was also very compounded what would have been the serious human distress. This time of the year, and we are here again now, is when people on very low incomes, and these are poverty level payments, are desperately trying to find a little bit of money for their children to be able to participate in some end of year kind of celebration. They don't turn up because they can't afford presents. They've got their children now with them, they have to try and grapple with the costs of care for children at a time when the children are no longer in school. This is a really, really difficult time for people on very low incomes. That is well known, and that is why so many community organisations are often out at this time seeking support from the wider community to try and help people on really low incomes. So in our view, the timing of this also indicated to us that there had not been any consideration or care for what was being done. And yes, of course, doors were closed. People who might have been able to help people were also having planned leave at that time.
And so essentially when this scheme commenced was later in 2016, was it your experience that that was when it really ramped up in terms of your organisation's involvement with people who were the subject of these letters or notices?
Yes, this is when we first became aware of what the government was doing with this Robodebt scheme.
So just to finish off on this letter, if we could please go to page 3 of the letter and just draw out the bullet points on that page. And Dr. Goldie, is it correct that these bullet points represented the actions that you were urging the government to take at the time?
Yes, they do.
And so you asked that action be taken to immediately suspend issuing correspondence. And you also, again, raised the recovery fee issue. And you also seek that matters already commenced be placed on hold. Is that correct?
That's correct.
And then finally, can I just ask you to expand upon that last bullet point? What was your view on this stakeholder round table? What were you hoping that would be able to achieve?
Well, it was clear to us. I mean, this scheme that was being unleashed on people had no involvement from any organisations outside of government who might actually be run by people on low incomes who understood what would help them to meet their obligations. It certainly did not include any organisations that have deep expertise like ours in being able to understand the nature and extent of the experience of interacting with Centrelink and what might actually help people. We had been very clear, as many other organisations working in this area, that we should be using technology to help people. If you get it right with data matching, it can be really beneficial to people because it is really difficult for people to receive more money that then is taken back from them at a later time because people on very low incomes do not have money in the bank. They don't put dollars aside and save them because they are already, in the jargon, dissaving, because their expenses are often much greater than their income. And so overpayments are a real problem for people in Centrelink who are relying on Centrelink payments. And so we wanted an opportunity for us to halt this, it was really a horrific onslaught on people, and then to be able to get around the table with government to start to work on how we could actually completely redesign something so it could be beneficial to people, and to make sure that people on very low incomes who knew best what that life is like to be able to drive the changes that were needed.
And can I just ask you about your point there, where you mentioned that your view is that that kind of data matching exercise could be beneficial. Can you just explain what you mean by that?
Charmaine, my colleague, might wish to add to it, but essentially there has been a long history of taking resources away from the Department of Human Services and Centrelink. People can never get through to speak to somebody. The rules can often be very complex for people. Understanding what your obligations are can be a real challenge. And so if we were to design data matching in a way that actually helped people themselves to see if there might be discrepancy as quickly as possible, then that would give you the heads up that you may need to be re-engaging with Centrelink to sort it out. So there's an opportunity for this to be used in a way that's beneficial, but it was being used to raise debts without any engagement, without any investigation, to help people to make sure that they weren't receiving overpayments that then would be pursued from them, in this case through debt collectors.
So I think the important point there to add would be that obviously have to be a human involved before any kind of debt raising or anything was proceeded with, but that if you were to use data matching in a more real-time way, you would be able to identify where someone was at risk of an overpayment, deal with it there and then, so that didn't accrue over time and become a much bigger overpayment potentially than what would have been the case if Centrelink had alerted the person to the fact that they were at risk of overpayment.
Do you know if that's happening with the single touch payroll system, which would make it easier, but we haven't yet investigated just how it is actually working? Can you?
So, look, we supported the legislation at the time for this very reason, that it would reduce the incidence of overpayments because it is very difficult to estimate your income in the future, particularly if you're working casually. We are seeking a review of the single touch payroll system, as we've outlined in our statement, Cassandra's statement. Because we want to make sure that it is working as it was designed to be working. And I can't say definitively from where I'm sitting whether or not that's the case across the board.
When's your review?
Sorry.
Sorry, you're asking for a review or you're undertaking a review?
Correct.
You're asking for.
Requesting that there be a review.
Do you know how it's being used though? Is it being used to pre-fill applications or?
It's a good question. That is my understanding, Commissioner. Indeed, the legislation as it went through the Parliament was such that the employer's income record would be provided to Centrelink, and that would be what would be used to assess the person's entitlement to their income support payment on a regular basis.
This may be getting a bit technical and you may not know the answer, but how do they align the Centrelink fortnight with the pay fortnight? Do you know?
It is a bit technical, but the crux of the change is that people's income support entitlement is now assessed on the basis of what they have earned in the past, as opposed to what they can expect to earn within that income support fortnight.
Okay, but what they've earned in a pay fortnight may not equate with what they've earned in a Centrelink fortnight, if you see what I mean?
My understanding is that it was to change so that your income support fortnight would no longer, the receipt of income would now be something that would be assessed that you've actually earned. So you would not need to estimate future earnings to satisfy the requirements for Centrelink.
Yes, but have they aligned? I mean, we can find all this out, I guess, but I'm just wondering because, as I say, a working fortnight and a Centrelink fortnight won't necessarily align precisely. So, you know, you may be working a different 10 days.
Correct, but as I understand it, that should not matter.
Mm-hmm.
But yes, best to get the detail.
All right, we'll look further into that. Thanks for your help.
That's all right.
Thank you, Commissioner. Ms Crowe, just moving into that sort of late 2016, early 2017 period, the statement talks about the Centrelink debt strategy group. Are you able to elaborate on that group?
Yes, so in early 2017, it was clear that there were a large number of stakeholders in our sector, as well as the community legal centre sector, concerned about Robodebt, and so we thought it would be prudent to convene a regular meeting of these stakeholders to discuss what we knew about Robodebt and also discuss ways that we could get the government to stop it because we could see the harm that it was causing in the community.
And who were some of the stakeholders?
So they included many of ACOS's members, as well as organisations like Victorian Legal Aid, New South Wales Legal Aid. I think Slater and Gordon attended one of the meetings, at least, Get Up. Not My Debt eventually came on board. So it was a range of organisations.
Where did Slater and Gordon fit in?
I can't recall specifically how we came to contact them to join the group, but it must have been clear at the time that they were concerned about what was happening with Robodebt, and they ended up joining at least one of the meetings, according to the notes.
I'm just wondering if there was a class action in the wind back then or not.
I can't recall if that was something that they specifically raised.
Mm-hmm. Right, thanks.
Commissioner, I note the time.
How much longer do you think you will be?
I think I'll be approximately between 20 and 30 minutes.
And we'd better take the morning break. Thank you. We will come back at 2:45.
All rise. The Commission stands adjourned until 11:45. The Royal Commission is now in session. Please be seated.
Yes, Ms Berry.
Thank you, Commissioner. Dr. Goldie, we were in, before the break, early 2017. If I can ask you about that time period. You say in your statement that on the 18th of January in 2017, you had a meeting with Minister Tudge, the then Minister for Human Services. Can you tell us about that meeting?
Yes, we met with the Minister and we repeated all of the concerns that we had communicated through our correspondence with him. We did everything we could to convey to him the level of human distress that was being experienced by people, and we urged, in fact I would say we pleaded with him to suspend the program immediately, and then a number of other actions to be taken, including the bringing together of representative groups to have a look at what was happening and to prevent the kind of experience that people were dealing with. That was really our principal ask, was for him to suspend it urgently.
Can we please have up Exhibit 3065? And Dr. Goldie, you'll see there that is a letter on the ACOS letterhead dated 19 January 2017, addressed to Minister Tudge. Do you recognise that as the letter that you sent on that date?
I do.
And if we can just call out the second paragraph there. Thank you. As you've just identified, Dr. Goldie, at that meeting, ACOS called for an immediate end to Robodebt, and you reiterated that call for a stakeholder roundtable. And you also raised in that paragraph, in the last sentence, the need to ensure that debt notices were issued, that they're accurate. And then you also mention repayment arrangements and the need for them to take into account a person's individual circumstances and vulnerabilities. Did you also speak to the Minister in the meeting about that?
Yes, we did.
And then in those bullet points on the first page, right down the bottom, if we could call them out, please. So it's correct to say there that really you are essentially reiterating many of the issues that you'd raised in the December correspondence.
Yes.
Would you agree?
Yes.
And on the 19th, which was the same day that this letter was issued, is it correct that you issued a public media release as well?
Yes, it is.
And do you recall what you spoke about in that media release?
Yes, we decided to issue the media release because we came out of that meeting with no confidence that the government was going to suspend the program. In fact, quite the contrary. Our clear understanding from that meeting was the intention was to pursue it. And so we felt it was really important for us to be as public as we could about what we were urging the government to do, which was to suspend and stop the program. And we described it as an aggressive abuse of government power, causing extensive stress, anxiety and harm amongst thousands of people who were caught up in the process. We urged for the gathering together of representatives of people on low incomes and people with deep expertise outside of government. We wanted an independent investigation into the Order Debt Recovery Program because it was apparent to us that this was a large-scale, very costly program that had been clearly designed over a long period of time, and how did it get this far without any of us having any idea that that's what they were going to do?
Would you expect for a program of this scale in the social security context, if I can put it that way, would ACOS generally be consulted on changes like that?
We certainly should be.
And how would that occur generally?
Well, you said should rather than were, so I don't know.
So it might be useful to describe some of the consultative processes that have been in place at different points in time. I might invite my colleague to lay some of that out.
Look, generally, where there are often, you know, in the case of budgets, and there are social security measures as announced in budgets, we and other stakeholders would be engaged by the relevant department to work through those measures and get a briefing on those measures. This didn't happen here. Often those measures require legislation, which is, I suspect, one of the reasons why governments typically consult with us and other stakeholders about them. But of course, that wasn't the case.
Sorry, just explain that. Because it requires legislation, why will they consult you? To head off the opposition, or?
It's in my experience, it's just been standard practice for governments to convene meetings with stakeholders, the Department of Social Services to convene a meeting with stakeholders to discuss budget measures in their portfolio.
Is it to inform you or to get your input?
Generally to inform us, but we also obviously provide input.
And is that effective or is that variable?
Well, it probably depends on the government at the time and their desire to get to change or not change the piece of legislation. There are varying. Often it's not often feedback is not taken into consideration.
Sure.
Thank you, Commissioner. For example, I referred earlier to the 2014 federal budget, which contained, we estimate, about $19 billion in cuts to a range of critical services, including income support, family payments, the age pension, proposal to prevent young people from having any income support for 6 months every year, and the list goes on. We were not consulted in any shape or form about any of those measures. Has become a very common practice to put these kinds of measures into a budget context, and then you wait to see what gets announced, and then, for example, in that case, we had to use the legislative processes to try and fight, and in many cases we did successfully stop a large number of those measures, but when there's no legislation, we don't have a parliamentary process even to engage with to try and prevent something which we clearly assess will very badly, negatively affect people on low incomes.
Thank you.
Thank you, Commissioner. If we could please bring up Exhibit 2872. Dr. Goldie, I understand that you received a response to your letter from Minister Tudge. So this letter here is from Minister Tudge and is addressed to you. It is undated, but do you recognise that as the letter described in your statement as Minister Tudge's letter dated 7 February 2017?
Yes, it is.
So you recall receiving that letter
Yes.
around February 2017. So if we could just call out, please, the third paragraph in that letter. And Dr. Goldie, is it correct that you were advised by that paragraph that data matching had been taking place under the Data Matching Program Assistance and Tax Act 1990?
Yes.
And then you were also advised in that letter that the online compliance system matched data in accordance with the relevant guidelines for Australian government administration.
Yes.
And then if we could pull that back and just pull out the paragraph below that. And Dr. Goldie, you'll see there it says, while the online compliance system uses more technology for part of the standard compliance review process, it does not change how income is assessed or how debts are calculated. Are you able to say what your understanding of that sentence was at the time? Did you note that sentence?
That it wasn't correct.
And why do you say that?
Because in the past, data matching was being used to flag up a potential overpayment or underpayment that somebody hadn't received as much income support which they would be entitled, and then that case would be referred to a compliance officer for further investigation. And that was not being done under the Robodebt scheme.
And if we could just bring up the second page and call out the third paragraph. Dr. Goldie, you'll see there that the letter refers to refinements that had been made to the system since it was first introduced. Did you know what those refinements were at the time?
Yes.
And are you able to outline what your understanding was of those refinements?
Yes,
Perhaps
included.
Mr. Crowe?
Yes. Would you like to say that one?
Oh, sure. So the government said that it would use registered post to send the debt notices out to people to ensure that they actually went to the person's current address. There were going to be some refinements made to the language used in the online portal to make it easier to understand. There was going to be a change so that people could request a stay on debt recovery if they could show that they hadn't actually received the initial notice. And I think that's the...
Register post.
Yeah, I got that. That's the extent of the changes.
And had ACOS been consulted at that point about any of those changes?
No.
And Dr. Goldie, in terms of that letter, did that letter address, in your view, any of the concerns that you had raised in your correspondence and meetings with the Minister?
They certainly didn't address the big problems with the scheme.
What were the big problems with the scheme?
The income averaging, the raising of a debt against that process, and the reversing of the onus of proof was at the heart of why this was such an aggressive scheme that was wreaking the kind of human distress on people. That was not removed.
So is it the case that you identified those three things that you've outlined very early on as the central problems with the scheme?
Yes, I mean, essentially as soon as we understood what they were doing.
And Ms. Crowe, there was evidence earlier from Dr. Goldie where she spoke about her statement in terms of the climate of fear that ACOS identified as affecting many income support payment recipients. If we move forward in February, a few weeks after the receipt of this letter, so later in February 2017, the statement that you've provided the Commission goes on to identify a person's private Centrelink information that was released to a journalist. Are you able to expand more on the views that are expressed in the statement?
Yes, so we were shocked, frankly, when someone's personal information was released to a journalist and published in a newspaper, not once but twice. And I had never seen something like that happen before in my time working in this area. But our worry was that would silence people who were affected by Robodebt, because it sent a clear message that we will use your personal information against you publicly. If you dare to speak out about what has happened to you, it should never have happened. It was a shocking abuse of the government's power at the time.
Just to be clear, that wasn't a case of Robodebt, but it was a case where somebody had criticised Centrelink processes
That's my understanding.
in a blog, and then that happened. But that then, you think, had a chilling effect
Yes.
for anybody who wanted to complain about human services or social services.
Correct.
Once again, anticipated my next question, Commissioner. I should
All right, you make me feel
answer
bad,
them in
Ms.
the other
Berry.
order. And sorry.
If I may add on to that, it also, we were shocked that because we had not seen it before, but it also indicated to us a serious lack of care about the health and well-being of Social Security recipients. It is well known that when you are on a very low income, you are often in a very highly stressed circumstance because of living in poverty. You may also have other factors playing out at that time. And so to see very powerful people naming you in the media without checking, the consequences of that could be very serious. So we were really disturbed to see that this was something that a senior minister would be prepared to do.
And can I ask, Dr. Goldie, in terms of your experience of the people who were speaking out against this scheme, did you identify that at any time, that perhaps the fact that they were no longer, a lot of people who were affected by Robodebt were no longer in receipt of payments, did you observe that to have any effect on whether or not somebody might be more willing to speak up against the Robodebt scheme?
Yes, and in some ways we've speculated whether that was the key reason in the end that we are here today. In other words, there are many examples of policy, practice and legislation that negatively affect people on very low incomes and cause extreme distress. In our experience, it is very difficult for a person to be prepared to speak up about that and to be in the media and to be exposed in that way when you are in those circumstances, and including when you are currently relying on the government department and the minister for your essentials of life, food and housing and looking after your children. This was different because Robodebt went back 6 years. And despite some of the rhetoric that gets played out about, people who rely on Social Security, many people rely on income support for a period of time, and then they are in a position to no longer rely on income support. And that's what a decent social security system is there to do, to provide that support when you need it. You never know when you're going to. So in this case, because the government went back so far, we were really struck that many of the people that were speaking out, and there were far more than we'd ever seen on any other kind of matter, were people who were no longer relying on income support and who were in paid employment and were very free to be able to say exactly what they thought about what was being done to them, because they were a long way away by that time from having to rely on Social Security and Centrelink and the ministers to meet their daily needs.
And Ms Crowe, moving forward to April of 2017, the statement refers to ACOS's receipt of the Ombudsman's 2017 report into Centrelink's automated debt raising and recovery system. What were your views on that report when you received it?
Well, I was fairly underwhelmed by the report's findings and recommendations, it must be said, because I felt that it failed to address the core problems of Robodebt, which was the reversal of the onus of proof and the use of averaging. I recall the report indicating that it's valid for the government to request that people provide their details about their earnings, you know, up to 6 years ago, and that's a fair thing for the government to do. And I disagreed with that finding. You know, we very much welcomed the own motion review by the Commonwealth Ombudsman into Robodebt, because we expected that it would go to the heart of the problems with the program and you know, basically argue for it to cease, but that wasn't the case.
And instead it was then cited in the years following as justification.
Indeed.
Thank you, Commissioner.
Did I preempt you again? Possibly.
Commissioner. So then moving further forward into 2017, it's the case that I believe both you and Dr. Goldie had a further meeting with Minister Tudge and the then Secretary of the Department of Human Services, Ms. Catherine Campbell. Is that correct?
Yes, it is.
And do you recall what happened at that meeting?
Yeah, it was a tense meeting. There was a lot that was discussed. We unfortunately don't have notes from that meeting, but to the best of my recollection, Robodebt was discussed, as was the use of the AFP logo on task force integrity letters. But essentially, our concerns weren't resolved in that meeting, it must be said. The meeting ended abruptly. And I do recall, I should note that Cassandra was joining this meeting by phone. I was there in person with other colleagues, yeah. I do recall at the end of the meeting pulling aside Secretary Campbell to raise my concerns about the Ombudsman's finding with respect to the 10% recovery fee, and that the government's position of sending information to people to whom that may have applied incorrectly, advising them of their rights to appeal that, was insufficient, because a lot of people would just not do that. And therefore, if the 10% recovery fee had been applied not in accordance with the legislation at the time, then that just wouldn't be addressed. But that was quickly dismissed by the Secretary.
And in the chronology attached to the statement, do you recall Ms. Campbell advising you that the department was implementing the recommendations of the Ombudsman's report?
Yes.
Do you recall whether any specific of those recommendations was mentioned, or was it a more general comment?
So, yes, in respect of the 10% recovery fee recommendation. You know, it was a difficult conversation because we were walking out at the time, and I was kind of being spoken over. But I recall her saying that the government was implementing the Ombudsman's recommendation as it was written.
Thank you.
If I may, I would also note that back on the 31st of January 2017, we wrote urgently to the Prime Minister about this matter. That's unusual for us to do in our advocacy. Normally we would be dealing with the Minister direct, but because of the seriousness of what we were confronted with, we felt once we did not get the response from Minister Tudge agreeing to suspend the program, we would go straight to the Prime Minister about it. We received a letter from the Prime Minister on the 20th of June 2017, and in that letter the Prime Minister relies on the Commonwealth Ombudsman's report and notes that they have made a number of changes to the system since January 2017 to improve the usability and accessibility of the system. We will continue to implement all of the recommendations set out in the report, and then, you know, we continue to support a strong and sustainable social welfare system. No preparedness to, in this letter, to engage with the serious issues that we had raised directly with the Prime Minister, which was affecting hundreds of thousands of people on the lowest incomes in the country.
And sorry, I'll withdraw that. So essentially your point there is that at that point in time, wherever you were raising these issues, you were being met with a similar response. And I think you described that response in your statement as downplaying concerns, and essentially continuing as business as usual. Is that?
Yes, it was
fair to say?
either, well, we're not doing anything different than it's always been done before, or we're dealing with the issues that have been raised, including through the Ombudsman's report, and there's no problem now. And indeed, as you'll probably take us to later, in fact, the government proceeded to want to extend Robodebt, not to shut it down. And this is in the face of repeated pleas bringing through the stories and experiences of people on low incomes, including suicidal ideation, including you know, all of the kinds of impacts that we've been describing. This is not a handful of people. We're talking hundreds of thousands of people. I've got no doubt that if this was an experience being felt by people who were perceived as being more politically powerful, who had more resources, we would have had a very different reaction from the government. But we were, you know, again seeing behaviours that were dismissing the nature and extent of the human cost of what was being done by the government, using extensive powers that we, because there was no legislation, we had no capacity to try and stop.
And Dr. Goldie, I might invite you to make further comment now on your reference to extending the scheme. What were you referring to there?
Might be best if I take that one.
Ms. Crowe.
So we became aware by someone working at the Department of Human Services at the time that the government planned to extend Robodebt to people with a vulnerability indicator on their record, as well as people living in remote areas who had previously been excluded from the scheme, which we were obviously strongly concerned about. And I must say, as was this person in the Department of Human Services. And And so we quickly wrote to Minister Keenan, who was the Minister at the time for Human Services, strongly advising him or calling on him to not proceed with that expansion of Robodebt.
A letter of the 2nd of August 2018 to the then Minister, Michael Keenan, brought to his attention again, we were talking about people with a mental illness, people who are homeless, people escaping domestic violence, people requiring being treated for an illness, and people with a serious addiction. And we were alarmed that this was the kind of policy that was being pursued by the government after extensive efforts to bring to their attention that even within the existing scope of the scheme, the level of human distress, but instead the government was planning to go further and particularly to target people who were knowingly actually with significant issues that they were at that time in their lives endeavouring to deal with.
And is it the case, you note in your statement that your understanding of the fate, if I can put it that way, of that measure was that that proposal was eventually paused. Is that correct?
That is correct.
Ms Crowe, the statement also mentions that in 2018, ACOS was consulted about changes to the online portal. This is at paragraph 75. Can you recall what the nature of that consultation was?
Yes, we were approached by someone from the behavioural science team within the Department of Human Services to be consulted about the updating of language on the online portal and changes to the portal itself, basically to provide feedback on the changes that they were seeking to make.
And you mention in the statement that you were strongly opposed to the proposal to use the online portal to secure consent from people to allow their debt to be calculated using averaging. Are you able to explain what you mean by that?
So the department brought to our attention that they were considering having a button basically to allow people to consent to Centrelink averaging their income over the relevant period to determine their fortnightly income and therefore determine the level of debt that they may vote, which we were extremely concerned about because it essentially allowed someone to consent to giving away their right to have their income support payment entitlement correctly and accurately calculated. And our worry was that a lot of people would end up doing that because they simply did not have time or energy to get the pay slips or bank statements. In the case of bank statements, they may have not been able to financially do that because they would have, in many cases, have to pay for the bank statements to be provided to them. And so it would be considered to be an easy option for people just to allow the department to average their income and consent to doing so.
And generally, would you agree that across the statement and the chronology provided, you describe in those documents a number of meetings that occurred across 2017, 2018 and 2019. And sorry if I can ask you to just say out loud for the transcript.
Yes. Yes.
Thank you. And those meetings included meetings with ministers, and there were also meetings with, as you've described, officers from the Department of Human Services.
Yes.
And then also meetings with the respective secretaries of each of DHS and DSS, including Ms Campbell and Ms Renee Leon.
Yes.
If I can take you then right through to 2019, one of the last meetings you describe in your chronology is towards the end of the Robodebt scheme, and that was a meeting with Minister Robert, who was the then Minister for Human Services, on the 14th of October 2019.
Yes.
Do you recall that meeting?
Yes.
Yes, we do.
And are you able to describe what happened in that meeting with Minister Robert?
We raised all of the ongoing concerns that we had. We again sought to paint the human face of the experience of people, and we asked for the Minister to create, again, a representative group of people outside of government and organisations that could work with the government on trying to change what was being done through technology in a way that could actually make it more beneficial, make it beneficial for people. The Minister made it clear to us he was not interested in doing that. He didn't see value in consulting with us, and his clear position to us was that his job was essentially, I'm not sure, I've got to check whether the language of welfare cop was used, but it was that kind of approach, was to, you know, make sure that people weren't, in my words, ripping off the system.
The Minister said rightly that the Commonwealth has an obligation to collect overpayments, and our clear message to the Minister was that, whilst that is true, what is happening here is that you are collecting overpayments that are incorrect or don't exist. And we made clear that our the number of notices that were being sent to people that either resulted in the alleged debt being reduced or waived entirely was around 20% at that time, which the Minister refused to accept, saying that the error rate was much lower, but that only referred to cases that were ending up in the AAT. Essentially, the Minister's approach to the debt recovery, his assumption was that a lot of people incorrectly report their income. It happens all the time, and it's his obligation to do something about it, and that's why they're not going to stop Robodebt.
And did the stakeholder round table that you first suggested at the end of 2016 ever eventuate?
No.
No.
Dr. Goldie, you may have already covered this earlier, but what is your view on what brought this scheme to an end ultimately?
The litigation.
And what litigation are you referring to there?
The test case that found the scheme to be unlawful and that led to the Commonwealth needing to pay money back.
And Ms Crowe, I might ask you this. Putting aside issues of lawfulness or otherwise with this system, given your experience in the area of social security policy and the fundamentals of that system, are you able to express a view on the logic or otherwise of this scheme?
Look, it's my firm view that irrespective of the legality, it's shocking that the government continued with the scheme that they knew was causing so much harm in the community. They unleashed this scheme onto hundreds of thousands of people, causing a widespread distress, and yet they continued. They knew about the distress the scheme was causing. They knew about that right from the start, and they continued. And that is something that I hope is never repeated. The government fundamentally failed in its duty of care to do right by its citizens. And it just should never have happened, irrespective of its legality. And I think that's why it is very shocking to me to see that even though so many people in the chain understood the effect of the scheme, and it continued it proceeded. There was no effort made to stop the worst parts of the scheme that was at the core of causing so much distress for people. That really is the shocking thing that's happened with Robodebt.
And, sorry, Dr. Goldie, did you want to?
I mean, we were, of course, working with legal organisations, and quite correctly, the question of the legality of the scheme was being investigated, and ultimately there was a test case that shouldn't have had to happen, but that is where it ended up. But if the Parliament had looked different, and legislation could have got through, it could have got through. That doesn't make this right.
And sorry, by that do you mean they may have actually made it legal to average income?
Exactly. I mean, in our parliamentary system, if the government had the numbers in the upper house to get the legislation through, they would have gone, oh, well, we'll legislate it then. And that would have gone through and it would have been exactly the same, potentially. And so what we want understood is that in this country, the fact that something is legislated doesn't also necessarily make it right and appropriate in terms of the exercise of government power. And so we need, out of this process, to make sure that all that we can do is put in place to prevent even legislation going forward, because we have seen it in other areas where once the issue of legality gets raised, it just gets fixed up. This is not a technical exercise. It's about hundreds of thousands. We've got millions of people who rely on social security. And you've heard testimony this morning of somebody who said, I will never come and get help from Centrelink again. We're one of the wealthiest countries in the world, and this is what we've done over this period, and we're still with no personal accountability for what occurred.
Something that Robodebt did was fundamentally undermine trust in government. We've seen that with the testimony this morning, but that's, they're certainly not alone in saying that they will never apply for Centrelink payments again because of the concern that something like this could happen again.
And so I might ask the question of each of you. Is there anything else that you would like to tell the Commission in terms of future recommendations or anything else?
Yeah, look, in terms of recommendations, there are a range of things that we have Cassandra has in her statement, ranging from improving the forms of communication to people where there may be an overpayment and making it very clear to the person how that alleged overpayment has been calculated and the reasons why Centrelink believes that there has been an overpayment. And it also very clearly stipulates their rights to appeal. We have in there a recommendation around developing guidelines for Centrelink that mirror the guidelines put forward, for instance, by the ACCC on debt recovery practices. We have recommendations in there pertaining to there needing to be a duty of care by government to ensure that government does not do harm, particularly for people receiving income support payments. And also, very importantly, there should be, where decisions are made automatically, there should be very clear rights for someone to see what decisions have been made, and they should have the ability to correct those in an easy way, where they can see, that what has been decided is incorrect.
Just a couple of comments from me. First of all, I do want to go back for a moment to the evidence that we've given about the combination of factors that have led to an ongoing sense of a culture of fear around engaging with Centrelink. And what we saw was during that period when the Robodebt scheme was begun in the December of 2016, which was timed around about the same time as the commentary that was being made about, welfare fraud and criminalisation and going to prison. It was very clear to us that what that would do was scare people so that they wouldn't engage with Centrelink. They'd pay the debt. And was that actually part of the understanding of others? That's what we thought. What that would do is it would mean more and more people would just pay the debt even though they didn't believe that they owed it, because they just did not want to get into trouble and they had a fear of engaging with Centrelink. So I did want to make that point because that was certainly our observation at the time and ongoing.
When you say, was that the understanding of others, you mean, was this deliberately done for that purpose?
It was obvious to us that in the sort of behavioural understanding that if you created that level of fear about engaging with an authority, when that authority came out and said you owe a debt, you'd be more likely to just pay it rather than challenging it. And if it was obvious to us, it seems to us it would have been reasonable to be obvious to including the government that that's what it would do. Did you want to add on to that?
No, not to that.
Okay. I'm just, is there further questions or on that?
It's just if you have
Okay.
anything further
look,
to...
The other thing that both my colleague Charmaine and all of us at ACOS want to say is thank you to everybody who has spoken up about this, including to Sandra this morning and to so many other people who had the courage to speak up and talk about the experience, because it's very hard to do that. Many organisations and many individuals, the many people who are perceived and often demonised and often vilified, and that has to stop. That has to stop. And what this process can do is call a stop to that and to thank people on lower incomes for having the courage to get up every day and to try and pay the bills and to look after the children and try and find paid work and engage with Centrelink to try and get some income support to be able to live lives with dignity and to participate and maybe have a present for their children when it comes to Christmas. That would be a real turning point for us. This system should never have happened, but it's the culture around government and community that allowed it to go on. And that has to stop. We already have other systems that are digitising decision making, that are sending out text messages to people, trying to make savings within government. We need a government that is there to help people and to provide support to people on low incomes when you need it. And I would really hope that we have an ongoing process from this Royal Commission that makes sure that puts the resources into the hands of people on lower incomes to be able to finally work with government on making sure that we design technology that will help people when you need it.
And
I'm sorry, I just
you've got
think
something else?
a really crucial recommendation, and that is to the government departments responsible for the administration of social security payments to employ at the highest levels people who have experience of receiving income support. I can't help but think if that was the case here and that there was a systemic approach to ensuring that people with direct experience of the system were within the department itself and helping make decisions about programs that the department was devising, that we would not have had Robodebt.
It's a bit of an anticlimax, but I've got some questions which are fairly particular. I was interested in what you said before, Dr. Goldie, about 2014 budget measures which were prevented from proceeding because the legislation wasn't passed. Yes. This commission's a bit interested in the legislative climate about the time that the Robodebt proposal went through, and you know that it's contentious whether it was known or not known that it actually would have required legislation. So I'm interested in what ACOS was doing in relation to, assume, agitating to prevent legislation being passed. In other words, were you talking to people in the Senate? How was it that you were acting on that?
Yes. So we did, in my statement, list out, here it is, the number of regressive measures that were being pursued by the government at the time to try and make savings.
I'm less interested in the measures than how you prevented it for our purposes.
And so it was direct parliamentary engagement, including with senators and those that held the balance of power in the Senate.
We're talking about the crossbenchers.
Yes,
and there were
yes, in order to persuade them to hold the line and to prevent the legislation from being passed.
So you actually had the experience of preventing social security legislation, budget measures from being passed by your engagement with crossbenchers effectively?
Yeah, for example, the cut to the energy supplement, the cut to the pension education supplement, the plan to make young people on youth allowance wait 6 months every year before they received any kind of income support, random drug testing, to name a few.
Yes, okay. As I say, a bit more interested in the process than the subject matter on this one because, you know, we're concerned with a particular set of budget measures.
It was through the parliamentary, working with the crossbench in particular, and the balance of power in the Senate.
Thank you. Then you, Ms Crowe, you cited around a 20% debt reduction rate. What was your source of information?
I'm just concerned that, well...
Well, you see, the reason I ask that is I know that figure was sometimes referred to in DHS material.
Right.
But there's other information which suggests that it may actually have been a fair bit higher.
Oh.
So I'm just wondering what your source is.
I don't know that I can go to the source, actually.
Okay.
Parliamentary privilege reason.
Oh, okay. That hadn't occurred to me.
But essentially that was the number of debts that had either been reduced or waived as a proportion of the total number of robo-debts that had been sent out as at March 2019.
Okay, thank you. Another question I have for you is, legislation went through on the 1st of January 2017 which allowed for interest charges, departure prohibition orders and extended the limitation period for debt recovery. Did you want to say anything about those features? Did they make any difference to anything in your perception? Or?
Well, look, we were, yes, so we were obviously concerned about the removal of the statute of limitations as well as the departure prohibition orders that were enabled under that Act. It seems, though, in practice the government did not go back beyond 6 years, at least in our experience of Robodebt, when they could have. That obviously would have been...
I'm not sure they had the data, Ms Crowe. So, all right.
And, of course, the departure prohibition powers that the Commonwealth then held was a very serious power to use. And so we were concerned about the government being able to use that power, I guess, in this context, particularly where the person may not even owe a debt in the first place.
Were you aware of people knowing about that?
No.
Okay. Mm-hmm.
I say no as in people did, like the general population very few would have had an understanding about the fact that those changes had been made.
Oh, yeah, but in practice, were you aware of people later on at any stage being concerned about that aspect?
I do recall speaking to someone who was concerned about the departure prohibition order. That's all I can recall about that.
Okay, thanks. Interest charges?
Yes, that's a concern, but I don't recall speaking to someone who had been having to pay the interest charges.
Right, thank you. And I think, we were aware of the AAT Tier 1 cases, either of you, that were proceeding and being sent back to the department on the basis. There were a number that said this wasn't a proper means of establishing a debt.
Yes, so look, I learnt about those cases through Economic Justice Australia, who was closer to that at the time. We didn't really have oversight of what was going on at the AAT directly ourselves, but I was concerned that what the EJA was saying to me was that cases were being essentially settled by the Commonwealth prior to them going further, presumably because they were concerned that they would not be able to defend them.
You didn't use those as leverage at all, the fact that there existed these decisions, or did you not have access to them to do it, or what was the situation?
I mean, for me at the time, I was finding out about this through other sources who were closer to it. You know, I knew that the legal centres were pursuing Robodebt in terms of the litigation. But that's the kind of the extent of our knowledge of what was going on at that time.
And final question, you said that you'd raised the recovery fee with Ms Campbell and the Ombudsman's recommendation. Now, I haven't got the Ombudsman's recommendations in front of me. My recollection is that there was a recommendation for review of recovery fee cases, at least where the person hadn't got the letter.
Correct.
So what were you raising with Ms Campbell?
My concern was the government's response to that recommendation was to write to people who had paid the recovery fee and advise them of their right to contact Centrelink to have that application of recovery fee reviewed.
As opposed to actually reviewing it?
As opposed to reviewing it on their own. And I knew from my experience working in this area that very few people would actually bother to contact Centrelink to request the review because...
You know, the funny thing about that is that DHS may have written the recommendation in the first place. Ms Hogan-Doran, did you have any questions?
No, there's nothing at this stage, Commissioner.
Right. Thanks very much for your time.
Thank you.
Very helpful. You're excused, I should say.
Thanks.
Yes, Ms Barry.
Thank you, Commissioner. I understand that Ms Marsh and
Ms Marsh? Mm-hmm.
and Mr Gregory will be taking the next witness.
Okay, thank you. Yes, Mr Gregory.
Yes, thank you, Commissioner. I appear with Ms Marsh. The next witness is Mr Jarrod, Jarrod Kagan, Kagan, who will give evidence on behalf of Probe Group, a debt collector engaged in the scheme by the department. He is separately represented.
Thank you. Yes.
Thank you, Commissioner. My name is O'Higgins, initials PK. I'm in counsel instructed by King & Wood Mallisons on behalf of the Probe companies and Mr Kagan.
Thank you. Jess, have you got some material?
Commissioner, while
Yes.
that's being organised, it would be convenient to tender the relevant material. It appears on the draft list as documents numbered, draft exhibit numbers 3146 through to 3191.
Thank you. Those exhibits will be admitted with the numbers in the schedule.
And I can indicate, Commissioner, that exhibits 3171, 3172, 3173 and 3174 are transcripts of telephone calls in respect of recipients, and that a non-publication order is sought in respect of those 4 documents, and I don't oppose it.
All right, and that's, I assume, congenial to everybody?
Yes, Commissioner.
Yes, I'll make those orders. Yes, Mr Kagan. Kagan or Keegan? What's the... Kagan, sorry. Will you take an oath or an affirmation? Thank you, if you'd administer that.
Your response is, I do. Your response will be, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes, Mr Gregory. Oh, take a seat. Thanks, Mr Kagan.
Thank you, Commissioner. Can you tell the Commission your full name, please?
Yes, sure. Jarrod Nicholas Kagan.
And you are giving evidence on behalf of Probe Group Proprietary Limited.
Yes.
Firstly, you're aware that Probe Group Proprietary Limited was issued with a notice to give a statement of produced documents, NTG-0039, and you've prepared a statement in response dated 20 October 2022.
The document said 007, but I'm assuming that's correct.
Yes.
But yes, we all served with the notice.
And there's an earlier notice, NTG-0007, which I think was the one just on the screen, dated 30 September 2022, issued to Probe Operations Proprietary Limited, and a statement of Ms Sophie Buhalis provided in response dated 17 October 2022. I know that you're nodding, but it's all being recorded. If you could give a
Yes,
response.
correct.
Thank you. Firstly, can you just explain the relationship between Probe Group and Probe Operations?
Yeah, sure. So Probe Group was novated. There was a contract which novated the assets of Probe Group to Probe Operations after a sale.
In layman's terms, Probe Group was allocated debts by Centrelink.
Oh, yes.
Elect as a debt collector from as early as 2016,
Correct.
or even earlier.
From what I can recall, it was 2016.
Right. And at a later point in time, a different company with a similar name, Probe Operations, overtook the work undertaken by Probe
Correct.
Group.
Yes.
There was a degree of continuity, it seems, because you were the Chief Operating Officer of Probe Group and then Probe Operations.
Yes.
Is that right?
Yes.
And during the period from December 2015 to July 2020, you held that position in respect of the different legal entities.
Yes. I'm not sure of the exact dates. I held various roles across that period, but there would have been a period that overlapped, yes.
Okay. Now, your role as Chief Operating Officer of Probe Group at the relevant times meant that you were involved in the business activities of debt collection at that level.
Correct.
Although you weren't involved in the day-to-day operations of the debt collection activities as they related to the Department of Human Services and then Services Australia.
Yes, correct.
Nonetheless, you held prior roles with Probe Group at different levels, which allowed you to be acquainted with the debt collection activities of Probe Group and then Probe Operations.
Yes, correct.
Now, can you give some context to the debt collection activities that the Department of Human Services engaged Probe Group to carry out?
So Probe was engaged by Services Australia to carry out debt collection activities on debtors that were no longer part of the system, and that included, it could be anything from written correspondence to telephone calls and SMSs.
When you say debtors who were no longer part of the system, do you mean the system of receiving social security payments?
Yes, correct.
And did you understand that to be the case because the department had its own process where it would recover alleged debts from persons who were still receiving benefits?
The reason we knew that is because the statement of requirement from Services Australia specified that we were only conducting activities on debtors that weren't part of the system. So I'm not sure, it didn't talk about whether or not they were performing services for their current participants. All we were aware of was the collection for non-participants.
Okay. And in terms of the value of the debts that were assigned from the department to Probe for collection, what can you say about that?
So that was specified in the statement of requirements, and that, from what I can recall, it was debts above $20 and I think lower than $10,000.
And how was Probe remunerated for its work in the debt collection?
It was on a commission model.
And was that the result of a negotiated arrangement between Probe and the department?
The tender documents, when I think it was Department of Human Services at the time, they specified that they required a commission structure in the tender documents.
Was that a usual structure for Probe to engage in with various entities for whom it collected debts?
Correct, yes.
What about a fixed fee structure? Was that also part of Probe's day-to-day business activities with various entities for whom it collected debts?
There were clients that we did collect on that had a fixed fee structure, yes.
What about other government departments? I'm not asking you to identify which ones, but did you have work for other Commonwealth departments?
Yes, we did.
And were they all commission or were some fixed fee? How did it work?
It was a combination of both. Some were on fixed fee and some were on commission, from what I can recall.
Yeah, and can you recall roughly what the proportions would have been?
Commission structures were more common in this collections industry. So I would say the majority of them would have been commission.
This is government department collection?
Yes.
Mm-hmm. Thank you.
And in terms of non-government departments, that private enterprise, was it more common to have fixed fee structures?
Absolutely, yep.
And were the fixed fee structures, without getting into specifics, fees which reflected the value of the debt?
I'm sorry, do you mind just clarifying the question?
Did you get to charge more if the debt was higher?
It would really depend on the contract. Some contracts had flat commission structures notwithstanding the value of the debt. Some would have different commission structures for different segments of debts. It would really depend on the contract.
All right, but that's commissions, which
Commissions, yes.
might be a percentage of a debt.
Yes.
So Probe gets paid more if there's a larger debt that it collects, in broad terms?
In broad terms, if the commission structure was flat, yes.
The fixed fees, though, was it Probe's experience that with non-government entities that there were flat fixed fees or structured fixed fees as the standard or common arrangement?
Sorry, again.
Well, in other words, if you were recovering $50,000, you might get a fixed fee of $5,000, but if it was $150,000, you might get a fixed fee of $10,000, that sort of thing.
If it was a fixed fee, it was typically one fixed fee across all values. However, again, it depends on what the client wanted. Some clients would want a different fixed fee for the different segments of the debts. So you could have scenarios of both.
Okay, thank you.
And was it Probe's experience that the debts allocated to it by the Department of Human Services were related to persons who were more likely to be in strained or distressed financial circumstances than those across other aspects of its debt collection activities?
Again, it really depends. Obviously, by virtue of the department it's a social service, so the debts that were referred were people that were receiving welfare payments. However, it's not uncommon for the work that we did for other organisations for, I guess, a certain demographic to have debts payable and not able to pay their debts that were referred to us.
Was Probe informed by the department about what debts were robo-debts, that is, debts according to what is defined in the letters patent as the robo-debt scheme, as opposed to other categories of debts that might arise from the department?
No.
And did Probe have any way of ascertaining that information?
No, we didn't.
You say in your statement that the information provided by the department included some brief circumstances about how the debt arose. How brief was that?
So we were provided with what was called debt reason codes, and that could be anything from a family benefits payment or a Medicare payment or something like that, and that would specify what the debt was in relation to, so the type of welfare that the debtor was receiving, but it didn't specify anything about how the debt was raised internally by Services Australia or the department.
So it was a category of income supplement, which was the identifying feature about the debt.
I'm not sure what income supplement is, but they would specify what type of debt, how it was, I guess, what it related to, so we would know whether it was what type of benefit they were receiving.
You referred earlier to the people who had debts which were assigned by the department to Probe related to those no longer receiving forms of social security. Was it Probe's experience through the information it received when engaging with these alleged debtors that very small amounts of money, that is, but in terms of alleged debt, would have a significant impact on their day-to-day lives?
Sorry, do you mind just clarifying the question?
For some people, $100 might not be a significant amount of money, and for someone who was living day to day or week to week, $100 might be significant. The feedback that Probe received from alleged debtors provided to it by the department or assigned to it by the department, did Probe get the impression that small amounts of money meant a lot?
Probe, we had a number of policies and procedures that dealt with any type of hardship flags that may be exhibited by a debtor. So in the event that we were an agent, in the event that an agent could pick up on those flags and could see that the debtor was in a position where any type of payment may affect them, we would deal with that in accordance with the policy and procedure, which was to ensure that the customer and their sustainability was always at the forefront of everything.
How closely was the department involved in these policies and procedures?
So the policies and procedures were based off the department's statements of requirements, which were provided to us at the start of the contract.
Was there regular engagement by the department overseeing Probe's activities?
So there was regular governance between Probe and the Department of Services Australia. There was also what's called a quality audit program where we would calibrate to ensure that we were acting in accordance with the policies, procedures and the statement of requirements. Yes.
What about the aspect of quality assurance in respect of telephone communications, for example?
Yeah, correct. There was that.
How was that done?
So that was done through what's called a quality audit process where we, as a business, we would have a dedicated staff to audit the interactions on the telephone calls between the Probe agents and any debtors. And then there was a calibration process with Services Australia. So they would work together with Probe to ensure that we were both aligned in terms of the way that we would assess that call.
I take it the internal quality assurance with Probe didn't involve that person listening to every single telephone call?
No.
Just a proportion of them?
It was a proportion, yes.
A percentage?
Off the top of my head, I think it was each agent had to have 2 calls audited a week.
And how were they selected within Probe?
I can't recall at the time, but typically it's a random process. It's a process where the calls would just be selected randomly.
And what about Services Australia or the department? Were calls provided to it for its audit process?
Yes.
And how were they selected?
I can't recall. It would have been done in accordance with the statements of requirements, and typically it would be a random process too, but I can't recall the exact nature.
It wasn't the same random calls that had been audited by your internal staff?
It may have been. Well, actually, it probably would have been, because we would have then had the assessment of those calls for them to then listen to and calibrate with us.
Okay, so they don't listen to them live, you provide them?
Yeah, we provide them, correct.
Thank you.
And how were the staff engaged in the debt recovery process directly with the alleged debtors paid?
Sorry, what do you mean by...
What's the pay structure for the people making calls?
Yeah, so our agents were remunerated on an hourly rate, and then there was an incentive program on top of that.
Based on?
The incentive program was based on a number of different metrics, which would include performance, quality and customer, and attendance, from what I can remember.
When you say performance, you mean the amount of debt that is agreed to be repaid?
Correct, yes.
What were the other features again?
Quality, and quality would typically be adherence to process, policies, procedures, also the way that they would interact with the customer, and attendance, so how often they were coming into work.
And the hourly pay rate, is that a casual type of arrangement?
It can vary between full-time, part-time or casual.
Where'd you draw your workforce from?
So workforce would be typically drawn from SEEK or, just publicly available type recruitment. We may at times leverage off partnerships, so recruitment agencies in the event that there was significant volume of people we need, or it could be internal promotions as well.
So I assume you operated call centres, or?
Yes, yes.
And where were they?
We have contact centres all around Australia. The contact centre for Services Australia, or the department, was out of Caulfield in Melbourne.
And the demographic of the people working for you, can you give me some idea of the sorts of people you would have ringing up?
Yeah, so typically you would get, I would say it would be average between 20 to, it really could be anywhere from 20 to 45, 50 years old. There was a significant probity process that the department had, and requirements, and typically government. So then when you do onboard them, they do have to pass, so that could potentially be citizenship or passing certain security and police checks and a whole range of other things. I'd say
what does that consist of, though? Just making sure they don't have a conviction, or?
Oh, absolutely, yes.
Anything else?
So we'd obviously do reference checks. We'd have a recruitment department that would look at employment history, education, anything like that.
And did you have minimum standards?
So any minimum standards would be documented in accordance with the client's requirements. So in this case, the Department or Services Australia would have a minimum standard, which would be documented in the statement of requirements, and then we as an organisation would have a minimum standard as well.
And final question, do you know the numbers of people you had working on DHS debt recovery?
At the time, I think it was around 20 people.
Okay, thank you.
Depending on who turned up, that sort of thing. The attendance record you referred to earlier.
I think, yeah. It was around the program was around 20 people. If people didn't turn up, then yes, there'd be less or more. But typically, what you do is you recruit the right number of people, and you factor in the fact that people may call in sick one day or may take leave, so you're always trying to have the right number of people there.
And sorry, I suppose I've got one more question. So is this what they did all day, every day? What's the calls for DHS?
Yes.
Thank you.
You indicated in your statement that the debts were not, I think, sold to Probe, but were assigned for a period. Can you explain that?
Yep. So Probe never purchased debt. We're not a debt purchase business. There are businesses where, and government don't sell debt, but companies, there are certain organisations that may realise that they've done everything they can to internally or through a third party to try and execute recovery, and then they'll sell the debt ledger to a debt purchase organisation.
And the arrangement in that circumstance reflects the original lender, as it were, getting something for the debt after exhausting their services by selling the debt ledger, and then the person who purchases the debt ledger takes the risk on whether they can recover more than they've purchased the debt for.
Correct.
That's not this scenario, though.
No.
Does that mean that there was a limited period of time within which Probe was able to recover the debts referred to it by the department?
So Probe was given 6 months to recover the debt. Obviously, in the event that there was a reason to refer it back to Services Australia, we would do that earlier. But if there was no reason not to do so, then we would have 6 months to recover.
All right. And the way in which Probe would go about that recovery process was primarily communication?
Correct. It was through written correspondence, voice or SMS.
So telephone calls, texts and letters?
Yes.
Was there a limit on the number of telephone calls, texts and letters that Probe was able to send to someone who had been assigned by the department?
Yes, absolutely. The ACCC ASIC guidelines specify how many interactions you can have and the type of interactions that you can have with a debtor. So any interaction that we had as a business was heavily governed and regulated by that. And then once we designed what we would call the collection strategy, it would then be provided to Services Australia to sign off.
Do you recall what those numbers were?
No, I can't recall.
Can you give an estimate from your recollection?
Yeah, typically you'd be looking between sort of one to two communications per week.
In any form? That is up to 2 texts
Up to
a week?
2. So a communication, notwithstanding the mode of communication, that would consider an attempt or a contact.
So over a 6-month period, a person who was assigned, to whom Services Australia or the department assigned a debt, could be contacted up to twice by Probe?
Again, it depends, because there's scenarios in which that generic treatment would be changed. So as an example, there's a range of different policies and procedures that would cater for different scenarios in which the debtor might find themselves in. And so, yes, if the plain vanilla situation where there was, for example, no evidence of a unique condition that a debtor may be in, then yes, you could make that assumption.
And the evidence of a unique condition, I understand you're talking about some form of vulnerability here. Would that depend on the customer identifying that in response to communication?
Absolutely, yes.
So if a customer didn't respond, Probe would assume that it could use the maximum number of occasions of communication per week over the 6-month period.
Yep. So if there was no contact from the debtor into the contact centre, then it would just flow in accordance with that.
All right. The fact that Probe didn't purchase the debt, did that mean that it wasn't able to take legal steps, commencing proceedings in one form or another, or enforcing the department's own non-prohibition orders or those sorts of things? It could simply refer to those features as part of its communication but not enforce them.
Yeah, look, I'm not an expert in debt purchase, but we were not able to execute any type of legal or prohibition order ourselves. That would have been something that the department or Services Australia would have to do in the event the debt was referred back to them.
But nonetheless, no doubt Probe referred to the potential consequences of non-payment in an attempt to extract the debt.
Correct.
And what did they include?
So, consequences could, off the top of my head, it could relate to further potential litigation by the department. It could refer to, I think it was general interest, garnishee orders. That was all specified in the statement of requirements.
What about prosecution, potential prosecution for fraud?
For fraud? Yes. I can't recall whether it had that specific scenario, but litigation or legal action was one of them.
Paragraph 24 of your statement, you identify that Probe received information from people it would make contact with who would say that this is the first occasion that they became aware of the debt. And you say, I think it's there on the screen now, that based on your experience in the industry, it was a common thing to hear. Did this form part of the feedback that Probe provided to the department about what it was hearing from people who were saying, this is the first we've heard of this?
In the event that a debtor would specify that this was the first time that they had heard of a debt, the statement of procedures specifically required the agent to tell that debtor to contact Services Australia and let them know that that was the case, and that would have been considered, I guess, a dispute or a query on that debt. So what we would do is we would then provide that information back, or we would assume that they would then go and contact Services Australia. And then, I mean, in terms of what would happen post that, no, we didn't receive any statistics or anything like that from Services Australia. The debt, if they hadn't made contact, it would have been referred back to us. If they did make contact and it was a valid query, then we wouldn't hear nothing more of that. It would just be withdrawn.
That is, Services Australia would from time to time withdraw debts from Probe that it had earlier referred to Probe.
Yes, that was common.
If that happened, or if you had to refer a debt an alleged debt that was in dispute back to the department, how were you compensated for your time, or weren't you?
We wouldn't have been.
Right. That must have been a bit of a disincentive for your actual agents to be referring people back to the department, surely, because it would affect their performance incentive.
I don't think so. From what we normally do is we'd look at a net recovery. So a net recovery would be what is collected over a recoverable debt. So that wouldn't formulate the denominator of what's recoverable, because that is going back to the department. Plus, one of the key components of any incentive is what I said before, which is quality, and you need to comply first and foremost with the policies and procedures. In the event that they recovered or did something like that, the whole incentive would be null and void because they're not following compliance.
But they'd still receive their base hourly rate?
Yes.
And they may receive a benefit in respect of performance if they manage to have a high level of debt recovery from their telephone calls.
No, that's what I was, I'll be more clear, but you cannot receive an incentive bonus if you aren't compliant and you're not performing in accordance with the statements of requirement and the policies and procedures.
And that relied on the quality assurance process, the internal quality assurance process, where someone listened to a sample of calls or a percentage of calls, and that may be picked up in that process.
Correct. Or in the event that if there was ever a complaint made, that would be brought to the attention as well, and we would look and review that specific call.
In paragraph 35, you refer to the prospect that the customer was unable to pay the overdue amount in full, and you've given evidence today that the debt could be quite low, $20 or maybe $50, but up to $10,000. Do I understand the starting point of this paragraph to mean that Probe would ask the customer to pay the amount in full at the outset?
Correct.
So someone might owe $9,000. The text from Probe or the letter from Probe or the telephone call from Probe would be to say, you owe $9,000, you're required to pay that amount immediately or within a short space of time.
The letter would start off with that. However, there would be a whole range of options underneath if they would like to discuss it, or if they have any issues with payment, and it would specify the different options that they would have.
Have you had the opportunity to listen to some call recordings in preparation for your evidence?
No.
Are you aware that call recordings were produced? You were?
Yes.
Well, based on your experience and your role within Probe, did you have the opportunity to listen to recordings from time to time when you were in the role there during 2016, 2017?
Yes. Well, typically within my role, it would be an escalated call, which would typically affect the safety of our staff or a threat towards Probe, where I would listen to calls.
Or indeed someone threatening self-harm?
That would normally be listened to and managed through the operations managers.
Though the concept of someone making a threat of self-harm or suicide, that's not a foreign concept to you in your experience after receiving a telephone call?
In my experience?
Yes.
Sorry, do you mind just clarifying again? Is it?
Well, the evidence produced from Probe includes telephone calls where people threaten self-harm, and they've been reduced to transcripts and de-identified, and they form part of the non-publication orders. What I'm suggesting is that's not surprising from Probe's perspective because of the level of financial distress in people that it was dealing with.
I think any time someone threatens their life, it's surprising and terrible. What we had as an organisation was very, very detailed processes and training to ensure that in the event that unfortunate situation came up, our agents were really well equipped to handle that properly and ensure that at the forefront of everything, that person's safety and well-being was there.
What did their training program entail and how long was it?
So the training, I can't recall the exact duration. Typically it's between 2 to 4 weeks. But that would include everything from the statements of all of the policies and procedures that were based on the statement of requirements that we had, together with best practice documents that we had internally and then signed off by Services Australia. And that could include anything from classroom facilitation, assessments, mock calls, real examples and mock examples of situations. And in this particular instance, we had a range of policies and procedures that specified exactly what they needed to do in the event that there was a flag that someone would threaten their life or any type of self-harm. Was
your 2 to 4 weeks training, whatever it was it all in person or partly online, or how did it work?
Yes, it was 2015 before the pandemic. Most of the
when people
the training
actually
was
saw
done.
each other.
Yes.
All right.
And to the extent that there was any training or procedures around this, that would have been identified in the material produced by Probe in response to the notice?
Yes, I believe so. I did have some help putting the information together. I do understand all the statements of procedures were provided.
You referred to the novation of the deed of arrangement between Probe Group and the department to Probe Operations and the department. Do you recall that it was a Miss Karen Harfield who signed on behalf of the department for that arrangement?
No, I don't.
You don't? In your statement, you refer to the Senate inquiry in 2017 through paragraphs 78 to 81. I should indicate, Commissioner, there's a reference to the content of the inquiry in paragraph 81, but that's not relied on in breach of.
All right, if it's not used for any of the prohibited purposes, I don't suppose it's a problem.
No. But I take it that that was unusual, that Probe's operations would end up before a Senate inquiry. I know that you're nodding again, but it's...
Oh, sorry, yes.
And at about that time, you must have also been aware of the level of media interest in late 2016, early 2017, particularly the criticism of the department's raising of debts pursuant to what is now understood to be the Robodebt program. Did Probe take any steps as a result of the media interest in respect of its dealings with the department to question the validity of the debts that it was being provided with?
So we had a policy that dealt with media, and any type of media inquiry we would then provide through to Services Australia and for them to deal with in accordance with their own internal media policies.
But Probe was aware, I'm suggesting, that there was a significant question in the public arena about the validity of the debts that were being raised by the department at that time, and that question was one of the things that Probe understood from the Senate inquiry as well. And I'm just asking about Probe's response to that. Was it all concerned?
So, look, Probe is engaged as an outsourced provider. We act in accordance with what our clients specify and their instructions, and so we acted in accordance with what Services Australia required us to do.
That is, the commercial arrangement was the commercial arrangement irrespective of the questions being asked in the public arena about the validity of the debts.
Sorry, I'm not following.
I think the short answer is no. Probe didn't get too concerned about the validity of the debts that was being raised in the media and from its understanding of the Senate inquiry.
As I mentioned, we acted in accordance with what Services Australia required us to do.
And in short, Services Australia required you to pursue the debtors and recover the debts.
Yes.
You're also aware, I take it, that the government made announcements in November 2019 about pausing debt raising under the scheme, and May 2020 in respect of the refunding of debts raised under the scheme. Did either of those announcements have any impact on the commercial arrangements between Probe and then Services Australia? Apart from the fact it wasn't being referred any more debts?
I think that's the ramifications were that Services Australia paused, but again, I can't remember exactly what happened back then.
One of the questions that this Commission is addressing is the anticipated and actual outcomes, including in a financial sense of the scheme. I take it your understanding of the situation is that because Probe Group and then Probe Operations were never able to differentiate between Robodebt debts and other debts from the department, that it would be the department who's in the best position to answer the amount of commission paid to Probe over those years in respect of Robodebt debts, which it would ultimately refund to persons following May 2020.
Yes.
All right. That is, there might be a clear element of the department paying not only commissions to Probe on the debts, but then refunding the full amount to the debtors as Probe understands it.
I can't go into how it's calculated or the way that Robodebt was done internally, but yes, Services Australia would have the information. We were never advised as to the debts referred to us, what was raised through Robo and what wasn't.
And it formed no part of the commercial arrangement that in respect of any debts which were said to be unlawfully raised and therefore ultimately recovered by Probe, that Probe would have to repay any of the commissions in respect of those debts.
Sorry, do you mind just repeating that?
Probe never had to repay any commissions it obtained in respect of the debts allocated to it by Services Australia.
Not from what I can recall.
Were you compensated for loss of the work?
No.
Thank you, Commissioner.
Thank you. Ms Hogan-Dory?
Nothing arising, Commissioner.
Mr O'Higgins?
No, thank you, Commissioner. May Mr Kagan be excused?
Yes, thanks, Mr Kagan. You're excused. And we'll take the lunch break till, I assume, 2:30 to be on the safe side?
Yes, thank you.
All right, 2:30 it is.
All rise. The Commission stands adjourned until 2:30 p.m. The Royal Commission is now in session. Please be seated.
Yes, thank you, Commissioner. The last witness we expect for the day is Ms. Catherine Dalton, who will be giving evidence via video link. The balance of the tender bundle for today is contained at numbers 3192 to 3242 on the draft list. And perhaps if Ms. Dalton can be brought onto the screen, but in the meantime I tender those exhibits.
There from our end.
Thank you. Ms. Dalton, are you happy to take an affirmation? I don't think you've got a Bible with you anyway, have you?
No, affirmation's fine.
All right, that'll just be administered now if you'll listen.
Your response is, I do. Solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
Oh, is that it?
Yes, Mr. Gregory.
Thank you, Commissioner. Can you tell the Commission your full name, please?
Catherine Margaret Dalton.
And you are retired, Ms. Dalton?
That's right.
You received a notice to give evidence and produce documents, NTG-0105, dated 30 November 2022.
Yes.
And you prepared a statement subsequently replaced by a revised statement on the 1st of December 2022.
Yes.
Thank you. Ms. Dalton, as your statement indicates, you were employed in the Department of Social Services in various capacities over many years, and relevant to this commission as an acting director at executive level 2 in the Payment Integrity and Debt Strategy section, Social Security Performance and Analysis branch, between December 2014 and October 2016. Is that correct?
Yes, that's correct.
And I should confirm, Ms. Dalton, your revised statement is true and correct to the best of your knowledge and belief?
That's right.
Yes. Who did you supervise in that capacity over that period of time? That is December 2014 to October 2016.
I believe Mark Jones, for a period, Anthony Barford, David Lawrence, Kristen Lumley, Jasmine Eales, Daryl Jones. Well, there may have been one other, but that's my memory of the team. Oh, Diana Ivaloska. Yeah, I think that's about my memory of the time.
And do you have paragraph 23 in front of you there of your statement?
Yes.
Perhaps if the document can be brought up on the screen. In your role as acting director, you had various responsibilities, including the development of policy regarding payment assurance and debt. If I pause there, what was the nature of the relationship between the Payment Integrity and Debt Strategy section within the Social Security Performance Analysis branch at DSS and the corresponding, if there was one, branch within DHS in respect of policy and payment assurance?
I believe there were two branches we dealt with in DHS, one for payment assurance and a different branch for debt.
And in terms of the delineation of the role, how would you describe that? what did DSS do in respect of that, and what did DHS do?
DSS had responsibility for payment assurance, but DHS conducted the reviews of people's entitlement or eligibility to social security payments.
How regular was the communication between the area you supervised and the corresponding area at DHS, or areas at DHS?
I think with payment assurance, it was very regular. With the debt, I can't be quite so sure. But we did have a project on which was a whole of government debt strategy, which involved multiple departments.
When you talk about payment assurance, what are you referring to there?
I'm sorry if I'm going to get the terms wrong, but it's either entitlement or eligibility to income support payments.
In a practical sense, does that relate to the fortnightly thresholds?
So my memory of it is that DHS, through Centrelink officers, would call customers in and take them through their whole entitlement to their payment. It was a random sample of customers. Mm.
And was that to do with payment, the question ultimately of payment accuracy?
Yes.
And in respect of debt, putting to one side the whole of government initiative that you speak of, what did that relate to?
I know we used to meet with DHS about risk profiling of payments. So that would be an element about making sure of accuracy and repayment of debt.
Are you familiar with the document described as the Social Security Guide?
Yes.
Guideline, yes. What role did the area you supervised have in respect of the questions of payment assurance and debt for the Social Security Guide?
Well, any of the policy areas I dealt with had responsibility for sections of the guide, so we would have had some responsibility, I believe, if my memory is correct. We would have had some responsibility for making sure the guide was accurate in its terms and descriptions.
Item C refers to providing policy advice on Social Security Appeals Tribunal and Administrative Appeals Tribunal appeals. Are you familiar with the standing operational procedures by which DHS referred or sought instructions from DSS about whether to appeal an AAT Level 1 matter to an AAT Level 2 or Tier 2?
Yes, I did work. I have worked in a number of policy areas, and that was always a part of the role of the job. To look at appeals.
Look at appeals.
Mm.
What level of supervision over that referral or instruction process sought by DHS did DSS exercise? That is, did it sit passively and wait for DHS to notify it that they were considering something, or did it independently make itself aware of what appeals were happening?
I'm afraid I can't recall exactly. I know we had a lot to do with our legal area about appeals as well.
That's the DSS legal area?
That's right.
Yeah.
But I do seem to recall that there was a process where they would come over from DHS.
But it's not something that you can recall with any detail now?
No, not to specifically say how they occurred.
Subparagraph D relates to reviewing and considering new policy proposals in respect of DSS legislation and policy related to payments and debt. Was that a regular occurrence during almost 2 years that you were the acting director of the area?
Well, if there was any policy proposal about payment assurance, payment accuracy and debt, we would have needed to look over them or develop them, or go to other income support areas of the department for input.
And in terms of the process by which that occurred, to your recollection over that almost 2-year period, how much notice would you be given of a new policy proposal? How much time would you have to look at it and consult in respect of policy and legislative questions?
Notice could be very short.
What do you mean
in the budget context? You know, need to get it quickly, review it, get any input you need on it. Could all have to happen very quickly.
What do you mean by very quickly?
Because you have to work on costings as well. Like it might have needed to be turned around in days.
So the area that you worked in was familiar with those confined timeframes in respect of new policy proposals?
Yes, but also some people in the team had a very long history with social security and legislation.
That is, because of their knowledge and experience in the area, they were
Yes.
able to quickly identify questions which might arise in that context.
Yes.
Who would you put into that category of those who you listed earlier?
Well, I think Mark Jones, Anthony Barford and David Lawrence.
In subparagraph H, you refer to seeking legal advice from internal DSS legal team as required. In your experience over that relevant period, did that include in respect of new policy proposals?
Yes, I believe so.
And do you have, or did you have the same degree of confidence about the legal team's ability to turn advice around in respect of new policy proposals in short timeframes?
They would always, I believe, give us an informal response if they needed more time to come up with the formal response.
Who did you report to?
As the branch manager?
Yes.
Murray Kimber.
And in terms of the DSS structure, is it your understanding that Mr. Kimber reported to the Deputy Secretary?
No, he reported to a group manager.
And who was that?
Well, I know it was Paul McBride, but I'm not sure about if it was that whole period. And then Paul McBride answered to the Deputy Secretary.
And at that time, is it right that that was Ms. Serena Wilson?
I believe so.
In respect of the new policy proposal, which became known as Strengthening the Integrity of the Welfare System, you identify in your statement that you were relatively new to the debt area, commencing there in December 2014.
That's correct.
Were you aware or made aware when you started that there was consideration being given to something that resembled ultimately that new policy proposal?
That was not my recollection. I just don't remember when I joined knowing of that.
But you were made aware of it, I take it, at least by mid to late January?
I seem to have memory of a phone call from DHS saying that this is coming over to you to have a look at.
And do you recall who telephoned you?
I think it would have been Jason Ryman as my equivalent in DHS, but I can't say for absolute sureness.
Did you maintain a diary or a notebook or a form of note-keeping system?
I always had my notebooks.
And what sort of things would you write in your notebooks?
Well, I would take, brief notes of meetings I attended. If I needed details of a phone call, I'd write them in my notebook.
You retired, I think, in late 2019.
That's right.
And what did you do with your notebooks upon your retirement?
Well, my notebooks would have gone from one job to the next. I'd had 2 other positions since that area.
That is, between that area and your retirement? Or
That's right. I had worked in 2 other areas of the department. So they were just my working day-to-day notebooks.
yes.
Mm.
And what happened to them upon your retirement?
Well, they would have already gone when I moved to the next job. I didn't keep any paperwork when I retired.
When you say they would have already gone, what do you mean?
Oh, I would have shredded them.
That is, when you finished your time
Yes.
as the acting director of the Payment
Yes.
Integrity and Debt Strategy section, in October 2016, you shredded your work notebooks.
Or just disposed of them in a paper waste. But yes, because they weren't relevant, I moved into a completely different area of work.
Are you familiar with the concept of archive documents?
Yes, but they were things that I put on hard copy files or my emails, on the system.
Do you think that you recall it was Mr. Ryman because you made a note of it at the time, or it's just something that was significant to your memory now, looking back?
I definitely remember a phone call, which is the sort of thing you would do, saying something's coming over and we need you to look at it quickly. But I can only imagine that it was Jason because he was the director and I was an acting director. So,
what makes this memory from what plainly were many, many phone calls you received over time significant?
Oh, I think because of the reaction of the section, actually.
What do you mean by that?
I only have a few really clear memories of this, and I can't say that my memory is accurate as to who spoke what. But I do remember someone saying they can't do it without legislation. What's going on?
Do you remember that being a general sentiment?
Yes, very much.
That is, in respect of those people you mentioned earlier, was there a common understanding in the team that there was perhaps incredulity, might be putting it a bit high, but something approaching that?
Yes, I would say so. But, no, I'll just leave it there.
Well, don't leave it there. Feel free.
Dalton. I mean, it was coming over. I don't know if it's once I actually saw it, and as a team we would sit and discuss things. But I have to say, from my memory being jogged by seeing my emails, we realised it was something that was yet to be really worked through. But there was a great degree of incredulity within the team.
And what aspect of it in particular we probably should make clear?
That you can't do it without amending the legislation.
Doing what though?
Oh, sorry, annualising debt.
Thanks.
I clearly remember people saying the recipient has to report fortnightly. You cannot then turn around and annualise debt.
That phrase, annualising debt, was it interchangeable with the phrase averaging debt or smoothing debt?
I believe it was.
Do you recall those phrases being used in respect?
Only from rereading my emails. I think annualising is the term that I remember most clearly.
And do you place the term annualising in the context of annual PAYG data from the ATO?
Yes, I suppose so, but that wasn't. Yes, it would have to be.
Is there any other way in which that annual concept was referred to within your team at that time?
I really don't remember.
Okay.
So we had a lot to do with the ATO on different projects. So
Are these general data matching projects?
I do remember discussions with DHS, meetings where we'd talk about data matching, risk profiling, all those sort of terms.
Was that by reference to the ATO, because the ATO held a substantial amount of data that might be useful for those type of programs?
Yes.
Were the discussions... Sorry.
Well, I was going to say, because I was new to the job, I was learning about all the privacy provisions and stuff of being able to access ATO data.
What was the general understanding once you were learning about those privacy provisions and various acts?
That things weren't necessarily straightforward.
In terms of accessing ATO data and using it for particular...
I believe so.
Returning then to what became the early days of the new policy proposal, at paragraph 32 you referred to receiving an email from Mr Kimber with a subject line, options to strengthen eligibility and participation requirements. We could have exhibit 3194 placed on the screen, DSS.5091.0001.0965. Thank you.
The document is in tab 27 of the volume of documents that I believe Ms Dalton has. And I'll also provide a copy of a list to my learned friends, which may assist this passage, which has the tab numbers next to it.
Thank you. I expect my tab numbers have changed a little bit over the course of the day, so this will be helpful. Now, Ms Dalton, there is an email on the screen. Can you see that?
Yes, and I've got it in front of me, I believe.
That's the same one. It's Monday, 12 January 2015, 11:22
Yes.
a.m. at the top. Yes, okay. This is an email from Mr Kimber, which forwards you a series of emails which are below, commencing with an email from Ms Ryan, Melissa Ryan, 8 January 2015, 7:08 p.m. To various people in DSS. You can see that?
Yes.
The statement on the 8th of January from Ms Ryan is, thank you for our talking with today. As I mentioned, we have been asked by Minister Morrison to prepare a brief by next week on, quote, compliance, unquote, including serious fraud, payment integrity options, etc., plus possible options that could be explored to strengthen eligibility and participation requirements for job seekers. And it continues. We refer then to the last email in the sequence, which was the one that was identified first. Was this your first introduction to the concept as far as you can recall, or identify in the documents that you've been able to review?
No, I'm sorry, I can't say. I don't have that recollection.
All right. Is this the earliest in time that you've been able to identify a document that relates to you?
I believe so.
And you said earlier that you reported to Mr Kimber. Is this simply a process whereby Mr Kimber is drawing something to your attention that may have started a little earlier because you were new to the area?
Yes, yeah.
He refers to a DEPSEX meeting later today. Are you able to shed any light on that meeting, or what it was the subject of, or how it related to this?
No, I'm sorry, I can't.
And if we go then in terms of sequence to Friday the 16th of January 2015, we ask that Exhibit 3196 DSS.509.0001.0834 be placed on the screen. And I think it is tab 17 in your bundle, Ms Dalton. It should be an email from Mr Kimber to Mr Whitecross, copying yourself, Mark Jones and Mr Barford.
Yes, I've got that, thank you.
Again, this was an email by which Mr Kimber was keeping you and members of your team informed about some progress in respect of what was brewing at DHS as a result of requests by the Minister.
Yes.
It identified that as early as October 2014, there was some consideration by Mr Jones in your team of the early stages of a concept advanced to him for advice by DHS.
Yes.
The attachment to the email from Mr Kimber, which was copied to you on the 16th of January, is entitled Request for Clarification on Income Testing Rules. And I'll just ask you to confirm, which I think is your tab 17.2, Exhibit 3197 DSS.5091.0001.0836. And
yes,
you can
got
see
that.
You can see that is the attachment to Mr Kimber's email, which contained the advice from Mr Jones, cleared by Ian Joyce in November.
Yes, so that went to the previous director.
Yes.
Before my time.
Yes. But that was why Mr Kimber attached it to the email to you on 16 January 2015, as you understood, to bring you up to speed.
I imagine so.
We move then to the following Tuesday, the 20th of January 2015, Exhibit 3198, DSS.5018.0003.0300, which should be your tab 3.
Tab 3. Yes.
And you can see it is on the screen as well. It is a further email from Mr Kimber to you and members of your team, Mr Jones, Mr Barford, Mr Lawrence, again updating you on a recent development which included a draft of what was then a developing executive minute to the Minister.
Yes.
In the third line, you can see the reference to smoothing income.
Yes.
Is that when you had regard to the attachment, which I think is your tab 3.2?
Yes, that's fine.
The same concept as you expressed as annualised debt in your earlier evidence.
Yes, I'm afraid that's the term I remember.
Yes, that's okay.
Annualised.
But if I can just, to be specific, take you to tab 3.2, which is Exhibit 3 199, the attachment to that email, you'll see
Yes.
the extract of the potential priority new policy proposal, one identified as PRYG cleanup, and subparagraph B refers to information obtained from the ATO and an assessment of their correct welfare entitlement based on that information. And in the next sentence, there's income smoothing methodology to apportion customers' income over the time.
Yes.
Yes.
Yeah.
That's what, how you understood the phrase annualised debt to arise? Yes. And when you talk about there being a general reaction within your team, in the sense that you gave earlier, was it in response to this email of 20 January with the attachment, or at a later point in time?
Yeah, I'm sorry, I can't recall.
But at least the concept, as you recall it, to which your team reacted was the one which is described in paragraph 1B or very similar to it in the weeks that followed.
Yes.
And as you outline in your statement, Ms. Dalton, there was a series of emails exchanged over the course of Tuesday, 20 January 2015, by which various persons within your team, and including Mr. Kimber, to whom you reported, provided feedback to this particular proposal for return to DHS.
Sorry, what are you asking me?
As you outline in your statement, and without going to each individual email, members of your team and Mr. Kimber, to whom you reported, provided feedback to this proposal on attachment B for return to DHS over the course of the day.
Yes, yes.
And I might take you to Exhibit 3210, DSS.5091.0001.0847, and I think it is tab 4 in your bundle, Ms. Dalton. Should be an email from Mr. Kimber to you, Mr. Jones, Mr. Barford, 20 January. Sorry, tab 20 in your bundle.
Tab 20.
Yes, my mistake.
Yes.
At the end of the day, a bit after 5 p.m, Mr. Kimber sent the email to you and members of your group for your information in respect of the return of the consultation or feedback from DSS to DHS through Ms. Halbert to Ms. Ryan. That's right?
Yes.
And as set out at the end of that paragraph, as discussed, here are our comments on the compliance part of the brief. We feel particularly strongly about the PAYG measure. And that email accords with your recollection of your team's response to the proposal in those terms.
As well as I can remember, yes.
Ms. Halbert, I'll take you to the attachment, which is DSS.5091.0001.0848.
Yes.
I think it is your 20.2.
Yes, I've got that.
The way that the feedback was provided, was by the inclusion of text boxes within the draft attachment B.
Yes.
And those text boxes included general comments in respect of the introduction under the heading proposed changes to strengthen the integrity of the welfare system, and then particular comments in respect of each of the policy proposals. And for present purposes, if you can turn to the page .0849 and .0850, you'll see the text box, which is in response to the PAYG clean-up proposal.
Yes.
Ms. Dalton, is it fair to say that by the end of Tuesday, January 2015, DSS was of one mind in respect of the need for policy and legislative change for this proposed new policy proposal?
Yes.
And very strongly of that mind?
Yes.
For the reasons which are identified in the text boxes which have been sent back
Absolutely.
at a relatively high level between the departments?
Yes.
Strictly speaking, it's not a new policy proposal yet, is it?
No, sorry, this is...
The brief which becomes the new policy proposal.
This, yes, to be clear, Ms. Dalton, it's described as a potential priority new policy proposal, but it was in fact a draft of an executive minute which was later addressed from DHS to Minister Morrison.
That's correct.
Thank you. Thank you, Commissioner. One of the features in the text box was a reference to the Keating High Court decision limiting the application of legislative changes retrospectively. You can see that.
Yes.
And that was something which was raised by members of your team in the course of its consideration of the draft.
Yes, I have no memory of it, but having read it, I understand it. So it must have been for discussion.
Thank you.
Something's happened.
Can you still?
Oh, no,
you can still see and hear me though?
Yeah, the screen changed, that's all.
That's all right. It's changed here as well, but that may only be in respect of the documents, Ms. Dalton.
Okay.
I don't think it'll cause us a problem for too long.
That's fine.
Do you recall that on the Friday of the same week, that's Friday 23 January 2015, the new policy proposal again, or the draft of the executive minute, which contained proposals for new policy proposals, again became a live issue as between Ms Golightly at DHS and Ms Catherine Halbert at DSS?
I wouldn't have recalled that, but if I've seen the documents, it's all made sense.
I can take you to your tab 35. It is document DSS.5037.0001.0568.
Oh. $11.19.
I think it's exhibit 3212.
So that's an email of 23rd of January at 11:19?
Yes, that's so, from Mr Kimber to yourself, Mr Barfoot
Yes.
and Mr Jones. And you'll see an email from Ms Golightly at 10:43am to Ms Halbert. I should confirm with you, Ms Dalton, that Ms Halbert was acting Deputy Secretary that day in place of Ms Wilson.
I believe she must have been to be in this chain of emails.
Because she would otherwise be out of the process which considers...
Yeah,
That's right.
because she was the group manager for a different area of the department. The social security area, I believe.
There is a reference to spending time with Catherine and Mark yesterday.
Yes.
Do you recall what that was about? There are a number of Catherines here. Was that you?
They're quite senior to me. I imagine that's Mark Whitnell, so, you know, group manager level.
And the response from Ms Halbert a few minutes later is that I told Melissa we would get back to her ASAP, and that's sent to Mr Kimber, your supervisor.
Yes.
And then, of course, Mr Kimber forwards it to you a few minutes later again. Let's pen a couple of attached inputs to these, please. Looks like it's needed pretty urgently. See that?
Yes. So this is one where I don't have the actual attachment.
I'll have it brought up on your screen, Ms Dalton. It is Exhibit 2137, DSS.5037.0001.0584. And in this form, it is attached to an email.
Oh, I believe I've got it.
You might have it.
Yes.
It might be behind tab 36.2, but I couldn't be confident.
Yes, yeah, I think that's it.
In this form, it was attached to an email from Mr Kimber to yourself, copying Mr Jones and Mr Barford.
Right.
With Mr Kimber's notes that he'd added some thoughts which were highlighted and kept them brief in view of the fact that it was given to the Minister. But if you go to the highlighted passages, you'll see a highlighted paragraph 7 on the page ending 0585, which identified the prospect of legislative and/or policy changes for some of the options, and the highlighted addition from Mr Kimber. And if you go to
at number 7.
Yes.
Yep.
Then if you go to page 9 and 10, pages 9 and 10 of 16, you will see an additional highlight from Mr Kimber in the last, by way of addition of the last dot point, in which he refers to the proposal.
It's not supported.
Not supported, and unequivocally not supported.
Yes.
And again, even though those in your team and Mr Kimber had reached this view on the Tuesday of that week, January 2015, when the full draft minute arrived, your team and Mr Kimber again reaffirmed that position in the response to Ms Golightly's request.
Right, yes.
Yes, all right. If you go then to tab 37 in your brief, Exhibit 2125, DSS.5037.0001.0619, you can see that by mid-afternoon, Mr Kimber was thanking everyone for their work on the new version of the draft brief, and he observed that he suspected it was not over yet. Good to get some further legal advice. You can see that?
Yes, yes.
Did that reflect to your memory, or did it prompt a memory, that there was a sense that irrespective of the strong position adopted by DSS earlier in the week, that Ms Golightly's return request indicated some pushback from DHS in maintaining the proposal for the minister.
I don't actually recall that sense. We would just been flabbergasted if anything operated outside of the legislation.
And did it seem very obvious to you that this proposal would have operated outside the legislation?
I may have been very naive, but I would never have imagined so. All my work in the department in policy areas had been applying the legislation, keeping the guide up to date, knowing legislation of different payments. As I said, I could have been very naive.
I can take you to DSS.5018.0001.2554. Exhibit 3216, and it might be tab 2 in your bundle, Ms. Dalton. It should be an email Friday, 23 January 2015 at 3:09 p.m.
Yes.
You have that, and you can see towards the centre of the page that what Mr. Kimber has forwarded yourself and those in your team was the response from Ms. Hulbert as Deputy Secretary acting to Ms. Golightly at DHS in respect of her request earlier that day to review the draft brief.
Yes.
And the notes made in the email from Ms. Hulbert to Ms. Golightly reiterated points which had been made both on the 20th of January, earlier that week, and earlier that day as within your team and Mr. Kimber.
I'm sorry, what are you asking me?
Ms. Hulbert's response to Ms. Golightly in the dot points reflected points made within your team earlier in that week on the Tuesday and earlier that same day as well.
I believe so.
I can take you now to the 4th of February 2015, Exhibit 3219, DSS.5091.0001.0840. It should be tab 18 in your bundle, Ms. Dalton.
Oh, 29. Yes, I've got that one.
Yes, and if I can take you to the bottom of the second page, ending .0841, you'll see that you sent an email to Ms. Pulford, Ms. Jura, and copying others in on the 23rd of January. It appears in response to Mr. Kimber's suggestion that it would be helpful to get some advice from the legal department as well. You recall that?
Yes.
And Ms. Pulford and Ms. Jura were, to your knowledge, in the DSS legal section.
Yes.
And you identify the background and a conversation that Mr. Barfoot appears to have had with them earlier concerning regarding concerns with the proposal.
Yes.
You said, we would appreciate your scrutiny of the proposals and advice on legal implications, impediments, what action would need to be undertaken to resolve legal issues, as well as some indication of the lead time required to obtain legislative change.
Yes.
That was the nature of your request, and you can see that on from the discussion within the legal department, from Ms Pulford to Ms Wong and Ms Dura on 28 January, it was Ms Wong who was allocated the role of responding to your request.
Yes. Yes.
Her response, if we go to the first page, 0840 at point 7, in respect of the PAYG cleanup, she simply referred at that point to the advice of Simon Jordan from December the previous year.
Yes.
And then over the next page, she referred to the Director of Prosecutions, Commonwealth, and Kellyanne Keating, 2013, High Court of Australia, number 20, where a reference to the effect of that decision on retrospective application of legislation was considered by the court.
Yes.
And the brief summary of it was, the main principle to be derived from Keating is that an omission or failure to act can only attract criminal responsibility when, at the time of the failure, there was an existing legal duty to perform the act.
Yes.
If I can take you to Exhibit 3211, which is now moving to 10 February 2015. Should be tab 24 in your bundle, Ms Dalton.
ESS.5091.000.0905. Did you say 24?
Yes. I'm hoping it's an email from you to Mr Jones and Mr Lawrence.
Oh, right.
10 February?
Yeah, 15:27, yeah.
Yes, 15:27 p.m.
Yes.
You forward the advice from Ms Wong to Mr Jones, Mr Lawrence and Mr Barford for their information, and said that you would arrange a meeting to discuss and do further work on the DHS proposal.
Mm-hmm.
Now, by this point in time, were you alive to the fact that the Minister was considering information sent to him by DHS, which had been the subject of your consideration on 20 and 23 January?
I can't recall.
I take you to Exhibit 3227, DSS.5091.0001.0034. I think tab 12 in your bundle, Ms Dalton. Should be a sequence of emails on Thursday, 26 February 2015.
Yes.
And the sequence is that Mr Britton from the Department of Human Services has sent Mr Kimber a copy of the signed brief from Minister Morrison, and Mr Kimber forwards the signed brief to a number of people, Mr McBride, Ms Halbert, Ms Wilson, Ms Carroll, someone else, noting signed briefing that indicates these proposals are to be pursued / further discussed, and then forwards it to you at about 2:03 p.m. on that date, and members of your team.
Yes.
And the attached signed briefing is Exhibit 3228, your tab 12.2,
DSS.591.001.0035,
Yes. Yes, I have a signed brief here.
which contains 11 pages 1 to 11 of 17 of a DHS executive minute to the Minister for Social Services for Action B15/125.
Yes.
And at least by this point in time, you had received Ms Wong's advice on 4 February 2015, which you forwarded to your team on 10 February 2015, which supported the position taken in the comments on the earlier drafts of that brief to Mr Morrison.
Sorry, could you just say that again?
It was a lengthy question.
Sorry.
By this point in time, you had received the advice from Ms Wong
Right.
on 10 February 2015, which supported or confirmed the observations made in response to DHS on 20 and 23 January 2015.
Yes, that legislation would be required.
Can I take you to tab 22 in your bundle, Exhibit 3229, DSS.5091.0001.0899. An email from Mr Barford to yourself on Monday the 2nd of March,
Right.
attaching possible legislative amendments to enable DHS measures. You can see that.
Yes.
And I'll take you then to the attachment. It should be tab 22.2 in your bundle, Exhibit 2556, DSS.5091.0001.0900.
Yes, I've got that.
You have that. And is yours a colour copy of that document?
It is.
So you can see various highlighting and writing in
Yes.
there. Thank you. I'll just wait for it to come up on the screen in a moment. Exhibit 2556, ending .0900. That's the document you're looking at, Ms Dalton?
Yes, that's correct.
This attachment, an email from Mr Barford to you, do you recall how this document was developed with its different writing or different colours?
No, unfortunately. So he's used red font to highlight different issues. But other than that, he's just making it very clear to me what the positions are.
Okay. The passage in red in the introductory paragraph refers to DOF requirements. That's the Department of Finance.
Yes, I believe so.
And the Department of Finance has a role to play when considering a new policy proposal in respect of exposure draft comments and costings.
Yes, I can come back with a whole range of questions.
The time frame appeared to be, by then about 2 days, Wednesday 4 March for preliminary advice. And the note is, I also note that the NPP checklist states there is no legislative change required.
Right.
I see that. All right. That time frame, did that cause you or your team any difficulty in providing at least a preliminary advice?
I don't recall, but we were used to working to very tight time frames.
That's okay. I could take you to Exhibit 3230, tab 29.2 in your folder, Ms Dalton, DSS.5091.0001.0973. This is an email sequence in which the second in the train is from you to Mr Hertzberg, copying in,
Oh, yes.
seems,
Yep.
a number of the DSS legal team,
Yes.
seeking urgent advice because the following strategies have been cleared by Minister Morrison for DHS to take forward as an NPP. And I take it that sentence reflects what you understood to be the effect of Minister Morrison signing the executive minute.
Yes, I believe so.
That is, once that minute was signed, it was a clear indication from Minister Morrison that it was to be developed as a new policy proposal.
Yes.
You refer to the checklist and the concern that it may require perhaps significant legislative change and was seeking advice. And again,
Right.
reiterated the time frame.
Yes.
I'm going to take you to a document. It may not be in your bundle. It is Exhibit 2227, DSS, yes, I'm told not in your bundle, DSS.8002.0001.002. This is an email trail which commences at the very end with some with your email. If we go to page .0004.
So you're saying it started with me sending it on to...
Yes, I'll just go back to this one. You can see the email there on the middle of the page on the left side. From you to others, the ones that I have just referred to.
Right.
And then it flows into the next response. So if we go back to pages .0002 and .0003.
Sorry, do I have those or it's just what you're putting on the screen?
Just what's on the screen, Ms Dalton.
Yes, fine.
Thank you. And we can see what is the large part of the body of information from Mr Hertzberg.
Yes.
Who has forwarded this to the other members of his team. Hi Millie, Anne and Susan. Do you have any comments on this before I send it? I've attached the MIN, which I think is Minister's Minute, which appears to be the most helpful document in actually setting out what each proposal actually looks like. The draft MPP is also attached. Any comments on my email below by lunch, if possible, would help me meet the ridiculous time frame they've given me. Even if you can glance at it and check any glaring errors, he would be appreciative. Now, do you recall seeing the draft new policy proposal at this time?
Well, all I can say is I must have.
All right.
If David Hertzberg had it, he would have got it from us, surely.
All right. If we could go to the bottom of page .0003 and the top of .0004, Ms Dalton, you'll see this relate his draft advice relating to Proposal 7. the employment income matching component, and that'll be put together on the screen so that you can read it. It may be that the second part of that is the top of 0003 rather than the top of 0004. Yes.
But is this income smoothing or not?
We'll just clarify that, Ms. Dalton. It's proposal 7, employment income matching, at the bottom of 0003 and the top of 0004. Yes.
I'm not sure that this is income smoothing. Peer central. Oh, status. I'm sorry, I'm not sure what that refers to. Which
Yes.
which element of the budget proposal? I don't know that it's necessarily income smoothing.
You might just try and
It's
locate the
data matching.
the draft new policy proposal, which is referred to there, given your earlier answer that the legal team would have received it from your area.
That's what I believe would have happened.
Yes. And it might just be able to, it may be that you can place this passage of Mr. Hertzberg's draft advice in context once you see the new policy proposal. We might just move on and see if that document can be found in the meantime. I'll take you to...
What was proposal 1?
We'll do that, I think.
No, yeah.
By reference to the new policy proposal when it's found. In the meantime, can I take you to Exhibit 3232 DSS.5083.0001.0004?
Do I have that in my folder?
Tab 11, I understand. This is an advice from Mr. Hertzberg on the same day as the draft which was circulated within the legal team in the previous exhibit that you saw.
Yes.
There appears to be some something that's happened to some of the spaces or letters in the second line, but he indicates in the third line, in general, I think it is clear that at least some legislative amendments will be required for the MPPs and there should be a bill for this.
Yes.
The extent of the amendments will depend on the details of what is proposed. The views are based primarily on the information about each of the first 7 separate proposals as outlined in the Human Services Minute to the Minister for Social Services of, it says 2 February 2015, but he identifies that these are preliminary views which may change. You can see that.
So number 7 doesn't mention any income smoothing.
No. Do you recall that that language was taken out of the draft of the executive minute?
Sorry, because I didn't even remember income smoothing, so I only remembered annualised. So, yes, I can't state anything definitively on that.
Mr. Hertzberg has numbered the items according to the executive minute, so it might be convenient once you've read passage 7 of the advice.
Yes, about the ATO privacy provisions.
Proposal 7, employment income matching.
Yep.
Yes. That we go back to the executive minute, exhibit 3228. DSS.5091.0001.0035, your tab 12.2. And if you go to page 10 of 17, ending .0044, you'll see increased use of employment income matching as the description of the document signed by the Minister.
Sorry, did you say page 10?
Yes.
Right. Yes, well, that definitely looks like. That definitely says about legislative change.
And the proposal as it's set out there, did you understand when you read this, or having read
I just feel the language is a bit different to what we had been working with previously, but it is all about ATO, I suppose, data matching, yes.
Yes, all right.
So it just talks about relying on the ATO data as the primary evidence, without explaining exactly what that is, which by implication you might think is the annualising you're talking about.
Yes, I think it must be.
But it just doesn't say it.
It's just different language, I think.
Do you recall what happened after you received Mr. Hertzberg's advice?
No, I'm sorry, I don't recall.
Have you been able to identify any emails or documents which relate to what you're holding in your hand there as the employment income matching proposal, number 7, in the executive minute, in terms of its development into a new policy proposal?
No, I can't recall. We'd have to have all the dates of the emails. If you're asking me if I can remember what happened next, I'm sorry, I can't.
And as I read your statement, you don't make any reference to anything that might have happened next.
No. So what date are we up to?
We're up to the 4th of March 2015, and that takes you through to about paragraph 74 in your statement. It continues through to paragraph 79 before you answer an additional question, but there is a reference to an email of the same date in paragraph 75 about costing of the new policy proposal, the PAYG component. You could go to Exhibit 3234, DSS.5091.0001.0206. I think it will be tab 37.2.
No.
I'm told tab 13.
Tab 13.
13. Okay. Yes, I've got that.
Thank you.
1705, yes.
This is an email sequence on the 4th of March involving 2 emails. The first from Mark Jones, whom you supervised, to others.
Yes.
Copying in Mr. Kimber, to whom you reported, yourself and others. We are happy with the costing and would appreciate you providing it to DHS budgets again to provide to Jason Ryman. Note I have checked...
They didn't have a secure system. We had to send everything to our budget area to be sent over to DHS.
Thank you. Note I have checked the costing parameters and discussed with Murray Kimber, who approves the costing. We can see that. But at the top of the page, Mr. Kimber forwards this to Mr. McBride, Mr. Jones, Mr. Barford and yourself. It seems to your secure email accounts.
Yes.
Hi Paul, for info, the following has been provided to DHS through our budget area. Details of costing for DHS compliance, MPP brackets PAYG component, and also based on preliminary legal advice, we believe there may be some legio changes required. This will depend on specific of implementation. We are suggesting that this be noted on the NPP so that government is then not surprised if it becomes a requirement. I've attached the preliminary advice or info.
Yes.
Now, as you understood it, up to this point, even in the conjunction of costing questions, DSS, that is the group comprising your team, Mr. Kimber, and those related to it, up to Mr. McBride's level,
yes,
had maintained the position that the particular proposal probably required legislative change, if not definitely required legislative change.
absolutely.
The response from Mr. McBride that you refer to in your statement at paragraph 77 is the following day, 5 March 2015, Exhibit 3235, DSS.5081.0001.9189, tab 10, I think, in your bundle, is Dalton. And he responds in respect of the prospect of legislative change in the NPP. That is, noting it makes sense.
Yes.
And to complete the sequence, on the 5th of March, if we could have Exhibit 3236, DSS.5081.0001.9154. This is an email from your tab 9, Ms. Dalton. At the bottom, Mr Kimber to Mr Britton, Mr Jones and yourself. May be that the redactions in the body of the email in the middle of the page have affected some of the lettering immediately above it, but would you agree with me that the...
Hi, Scott. For me. It's still saying legislative amendments.
Yes, we advise the NPP does need to indicate that legislative amendments will be required.
Mm.
And Mr Britton responds, of course, at national manager level from DHS, thanks Murray.
Yes.
And up to, or sorry, beyond that point in time, you haven't been able to identify, I gather, what happened to the concept of legislative change in the development of the new policy proposal.
No, there were no more emails found relevant, I understand.
I have seen, and I am looking at another email which may not be all that critical, but it's DSS 5081 001 6753. And according to this, on the 3rd of March, which is a bit earlier, you'd asked for an email to be forwarded to Mr Ryman, which thanked him for a copy of the draft NPP and in relation to the legislation said that it had been raised with the Public Law Branch and you'd be getting advice tomorrow, but it might be a case of needing to better understand how DHS proposes to implement the measure within existing legislation. Does that ring any bells, 3rd of March?
It sounds correct.
But then the way that's responded to is through a Mr Jeng, which asks him to send it back to you, and it thanks you, and it is sent on to you by Mr Jeng. The email of 7th of March thanks you, apologises for not getting back to you sooner, and tells you that they provided some comments back to Finance late yesterday through DSS on the costing assumptions. They did raise the averaging, which we hope we have now adequately explained. And then it goes on to say, we have been working with our debt management colleagues to incorporate debt recovery arrangements into the new process for the PAYG activity. DHS have the RIS. Does that mean anything to you, RIS?
Every budget proposal had to have stands for risk something, I think.
Okay.
Regulatory
impact statement. Yes, yeah. Impact statement.
Okay, DHS have the RIS in hand, and I know the NPP has been assessed by the Australian Government Solicitor for the Constitutional and Legislative Authority risk. That's it. So that seems to be Mr Ryman's response to you on the 7th of March, for what it's worth. Does that ring a bell?
No, but it sounds right in the context
of
doing a budget measure.
Yeah, but what would that mean to you, if anything, about what on earth was happening with the legislative change for averaging? Because it doesn't seem clear.
You read something out, I think, about the Department of Finance?
Yes.
So Department of Finance would come back to us or DHS with a whole lot of questions about how the measure would work. So either they've had to explain that there would be legislative change or that they've modified the proposal, or that's just my best guess, the sort of discussion that would have gone on.
All right. But were they likely to say anything about legislative requirements or anything? Finance?
Well, if they're seeing documents which keep specifying it, I would have hoped they would raise it. I can only imagine that they would have.
Yes, thank you. And can you tell me who Mr. Peck, PEK, is at DSS? Does that mean anything to you?
Oh, at DSS. Well, as I said before, any sensitive, any secure emails we sent, we had to send it through our budget area to go to the DHS budget area because they didn't have the same secure system. I think he was a budget person.
All right, thank you.
But I could be mistaken.
Because another email I can see, which is CTH 302300140534, is from him to Mr. Ryman, and there's a response from Mr. Ryman explaining some questions about the proposal. It's CC'd to you, but it doesn't really touch on the averaging question. It's got a lot of other issues about the proposal.
I do remember the name, but I can't. I can only. So Heidi was in the budget area, so I think Kevin possibly worked with Heidi.
Heidi Lukban, Lukban.
Yes, yeah.
Her name's on the email too. All right, I don't know if that cleared anything up at all. I don't think it did.
Ms. Dalton, do you recall that the draft new policy proposal became a feature of the May budget?
I can't say that I recall necessarily, but it obviously was, so I can't recall the specifics at the time.
You remained in that position through to October 2016.
That's correct.
And then you became in a position relating to disability employment assurance section within DSS.
That's right.
You remember that soon after you moved into that role, November, December 2016 and early 2017, there was considerable media attention around the online compliance intervention program operated by DHS.
I think I remember some comments within the department.
Would you elaborate on those?
Oh, just that people who came up with the measure may have moved on in DHS.
Do you mean promoted?
Oh, I don't think it was promoted.
Right.
But I could be wrong.
Well, what do you recall?
That they were moved out of the area was what I was told, but that's just like hearsay. I don't really know.
Do you remember at that time turning your mind back to the question which we've addressed here today about legislative change being required for that process?
No, I don't recall.
In mid-2016, before you moved to the Disability Employment Assurance section, your area was involved in the question of whether the 10% penalty fee would be applied in the online environment. Do you remember that?
Yes, vaguely, I do remember.
I'll try and prompt your memory a little bit, and I'm not sure
Right.
these documents are in your bundle. So
I remember being in some sort of meeting, I think, where it was discussed.
Thank you. I appreciate you may not have seen these documents, so I'll have them on the screen. Exhibit 88, DSS.5006.0001.0509, Friday 1 July 2016. So Ms Ulrich to Ms Lumley, who I think you've spoken of before.
Yes, she was, Kristen was in the team. I can't remember who Elizabeth Ulrich is or was.
Over onto the next page, .0510, her email footer describes her as a lawyer, social security and family section.
Oh, I don't remember her name, I'm afraid.
It's okay. The lengthy email trail involves, goes back to 30 September 2015 within DHS, various persons there, and appears to come to you on 1 October 2015 on page .0517. We'll give you some time to read that. I know that you haven't seen this recently.
So sorry. Who does it start with?
Well, it comes to you from Mr. Ryman on Thursday, 1 October 2015.
Yes, yeah.
But the start...
Hi, Catherine.
Yes.
It is sort of familiar. Yeah, it is sort of familiar.
This sequence of emails relates to what was then described as a PAYG element of strengthening the integrity of welfare payments budget measure.
This was, I imagine, was part of the implementation of the measure.
Yes.
I don't recognise all the names. Actually, I only know Jason's name. So, but I do believe there would have been a meeting about this, because it's certainly ringing a bell.
And the email trail continues over a period of time through to mid-2016.
Is this the end of it?
If we just pause on those pages, no, it's not.
Right, okay.
But if you go to the top of page 0514, that's the document
Yes.
on the left, you can see Thursday, 16 June 2016. There is a discussion which you are copied into about amending the Social Security Guide for the 1 July 2016 guide release. Do you recall that there was a need to address a question of the Social Security Guide relating to the 10% recovery fee?
I don't specifically remember, but it makes sense.
And does it make sense because there had to be some change to the guide, to your recollection?
Well, not from my recollection, but only in looking at it, it would make sense that you would have to update the guide.
Do you recall meeting with Ms. Lumley or Ms. Pulford or Ms. Ulrich or others relating to the question of advice in mid-2016?
Not specifically, but we regularly, Kristen Lumley was in my team, so we would sit and discuss things, probably with others in the team as well, thrash an issue out. And we had fairly regular discussions with the legal team, so but I can't say specifically.
Do you recall anything in terms of the discussions which related to whether it was appropriate or not for the imposition of the 10% recovery fee in the online environment?
I can't remember the specifics, but I have a sense that it was quite what would you say, feisty discussion? I don't know.
And what were the conflicting views?
Or the appropriateness of it all.
When you
It's
say,
just a sense.
yes. The sense.
So I'm sorry, I can't remember anything more specific.
Yes. When you say the appropriateness of it all, do you mean the inappropriateness of it all?
Potentially, yes.
Okay. And are you referring to the 10% recovery fee, or are you talking about the concept of the online compliance program more?
Well, just in this instance, you know, talking about yet another fee on the, you know, charging the customer with another expense. Yep.
Do you recall?
I mean, there were pros and cons for it all. I'd have to say that for the fee.
It seems clear from the discussion which started in September and went through to mid-16 about the question of the recovery fee and the amendment of the Social Security Guide that what was the subject of advice in January, February and early March that is reflected in the documents you have been taken through this afternoon proceeded without legislative change. Do you recall that?
Yeah, no, I don't have any memory of that, but I do remember that there would have been ongoing discussions about implementation, like the letters that were to be sent out to customers and things like that. But no, I don't remember otherwise.
And your recollection, prompted as it is by the review of the documents that have been made available to you, does that allow you to express even the vaguest recollection of how it came to be the measure was introduced without legislative change?
Unfortunately, no.
Mr. Gregory, could you just look at these?
I might just have a moment.
One of them appears to be a DSS response which goes back to DHS, a list of items.
Yes. I might just try and track down an exhibit number.
Thank you.
First is Exhibit 2552. DSS.5006.0002.3934.
Oh,
And Ms Dalton, were you provided with a copy of this document in the preparation of your evidence? It's an email from Mr Barford. This is, well, at the bottom of the page from you, 24 March 2015. If we could have the second page up as well, .3935, thank you.
here's an update, Jacob.
But you may need the context of the other documents, which I think are from the same date.
Yes, just having an exhibit identified.
22nd of April, I think. So, Sarah's transport. So that list of measures and dates doesn't make any reference to legislative requirements because Anthony has said the key area likely to require legislative change are only at the scoping study status for now.
What does that phrase mean to you?
Yes, I'm not sure actually. But they were still working on it. But gee, it's close to, oh no, that's March. And this is April. 22nd of April, and that's a month's difference. So I'm not sure what's going on there.
But if you look at the content of the 24th of March email and you look at item 7, does that mean anything
Yes.
to you?
Just saying when it's to be implemented from 1 July 2015.
But it also says PAYG cleanup under existing processes.
Oh, that's true. Yeah,
Potential to vary method, including change to trusted source. Does that ring any bells, mean anything to you?
under existing processes. Potential to vary method, including. No, I'm sorry, it doesn't.
And have we had any luck with the other documents?
It's not an exhibit, but it will soon be.
All right.
If we could go to the attachment, that is the update on DHS MP.
Sorry, can I just say, just wondering, if something was possible to be brought in from 1 July, I could be completely wrong, but not the full scope of it, given they were still looking at legislative change as part of a scoping study. I don't understand it otherwise.
All right, I'll take you to the attachment to that email of 24 March 2015. It is Exhibit 2550, DHS.5006.0002.3936.
I'm not sure if that's an attachment to this email or the other one that I handed you, Mr. Gregory.
This looks like it. So we need to go to number 7.
I think it is that email because of the consecutive numbering.
Okay.
Although the other document that you handed me, Commissioner, has the same title of attachment.
I feel that I turned them up together.
Yes.
So,
What does increase review? Any proportionally. So unless DHS had gone to AGD for advice about legislation, otherwise there's nothing really there.
what about the bottom couple of lines? DHS detailed advice. Same basic process.
Yeah.
I'll leave you to read it.
Same basic process as current, not using ATO TFN data, use welfare file. So that must be the way DHS did it at the time. Potential for payment period, salary or income period match issues to be resolved. Yeah.
These were
Sorry.
things, I'm sorry, I was just going to say, these were things which I think were CC'd to you, but it's not ringing any bells with you now?
No, unfortunately not. I just wonder about, has DHS had input or advice from AGD as yet? I don't know. No, sorry, I can't enlighten you on that.
The other document is an email of 24 March 2015, cth.3023.0014.1916. I tender it, I think it will become Exhibit 3243.
What about the one that's on the screen now? Was it already an exhibit or not?
Yes, 2550.
Okay, and the next one, as you say, will be...
So, sorry, just reading it again. So it's saying they're going to increase the reviews. So that just makes it sound like it's a normal practice. We're just going to do more. And then they're going to change ATO from matching source to a trusted source agency. I have no idea what that means. ATO match offers and declared income only. It all just sort of makes it sound like it's what we do now and we're just going to do more of it.
Okay, it would be, I suppose, if you don't remember at the time what was being discussed, though, we can only look at it and draw inferences, I suppose. That document's 3243.
If Exhibit 3243 could be placed on the screen. This email sequence is of the same date, 24 March 2015. It'll come up shortly, Ms. Dalton. Again, you are copied into an email between Mr. Barford and a Rob Barringer. You recall who Mr. Barringer was?
Yes, I believe he was in budget area. Remember Rob?
CC to you, subject document for secure transfer to Jason Ryman. Many thanks. Rob, could you organise this document to go to Jason Ryman at Human Services via Secure? It is a reflection on possible legislative change and timing required to support the DHS Strengthening Welfare NPP suite of measures and is provided to Jason FYI. The email is, Jason, this is for our summary of discussion as provided, this is our summary of discussion as provided to DSS Public Law Branch. Following Friday's meeting, read the DHS MPP and has been provided for your information. We'll stay in touch re any policy change required to support the NPP. Many thanks, Tony Barford. And the attachment seems to be the same attachment as the one that we just looked at.
It's not on screen yet.
No, not on the screen yet. Things are happening behind the scenes. It may not be able to be shown.
Okay,
Oh,
you said the content, but, here we are.
Oh, something's come up. 24th of March at 13:31.
Yes, that's the last in the sequence. And you'll see that you are copied in at 12:22 at the bottom of the page and 12:24 in the middle of the page.
Yes, yep.
The attachment, as it's described at 1:31, is the same as the attachment to the previous email of the same day.
Okay.
Yes. You recall some activity on the 24th of March in respect of this aspect of the new policy proposal?
I'm sorry, no. It's a reflection on possible legislative change and timing. But that other document doesn't really make specific reference to it, does it?
Reference to what?
Legislative, or is that where it said it was in scoping, the legislative change?
Well, we didn't go through all the items on it, Ms Dalton,
Okay.
so...
Only the one relating to the PAYG clean-up, which was item 7 on the executive minute.
Yes.
And the new policy proposal, yes.
I can't add anything, I'm sorry.
Very well. All right. Thank you, Commissioner. I have no further questions.
Ms Hogan-Doran?
No, there's nothing arising, Commissioner.
All right, you want Ms Dalton excused?
Yes, thank you, Commissioner.
Thanks very much, Ms Dalton, you're excused.
Thank you.
And we can probably end the video connection there.
We can, yes. Commissioner, I can inform the Commission that the letters referred to by Mr Morrison in the course of his evidence have been the subject of discussions between the representatives of the Commission and the Commonwealth and Mr Morrison. It has been agreed that these be tendered and appropriately redacted versions of the two letters. They've been provided through today, I think, through Ms Hogan-Doran, and may now be tendered as exhibits 2687 and 2688.
Right, that's the gap I'd left, is it?
Yes.
They'll be, well, they were admitted in anticipation, I think, so good to have the copies.
Thank you. I'm told they'll be uploaded in the usual way in the exhibit
Thank you.
lists. Yes. Nothing further.
All right, till we meet again, Ms Ogendoran, in January.
I'm sure we're all looking forward to it, Commissioner.
Yes, I hope you all have an excellent Christmas for what it's worth. Thank you, Billie Jane.
All rise. The Commission stands adjourned until 23rd of January.
16th, I think, isn't it? Or 23rd? 23rd, okay, thank you.